propose that we brief the ANC in Lusaka, the PAC in Dar es Salaam, and President Nelson Mandela, then still incarcerated. I vividly recall raising concerns about the feasibility of such bold engagements. How would we make contact? Who among us had the network or credibility to initiate such high-level connections? The response was grounded by resolve. This is the resolution of the soldiers. As the head of government, you must find the way. Fortunately, we had courageous and principled individuals within Mthatha who were active and supportive of the changing political tide. Amongst them was Advocate Dumisa Nsebeza, a private lawyer, then late Dr. Zola Dabula, a medical practitioner, and Professor Mabute of University of Transkei. Soon thereafter, I dispatched Brigadier Titi Matanzima and Brigadier Keswa to Tanzania to brief the PAC, while Lieutenant Colonel Mkalali was sent to Zambia to brief the ANC. These were not diplomatic missions sanctioned by Pretoria. These were clandestine, high-risk undertakings that would later redefine the role of Transkei in the liberation project. Their missions were ultimately successful. The engagements contributed to the growing rebellion led by King Sabata Dalindyebo, which reached a climax in 1989 at his Great Place. Following his exile, the king died in Zambia and was disgracefully buried like a pauper by K.D. Matanzima. This act further fueled the rebellion and deepened public outrage. During King Sabata Dalindyebo's funeral, we witnessed what had previously been unthinkable: open support for the liberation movements inside a so-called independent homeland. The United Democratic Front, led by Winnie Mandela, Elijah Bahai, who was a COSATU president, Peter Mkaba, a youth league leader, and Bulelani Nguga, among others, arrived in Transkei in their organization colors and liberation flags. That moment marked a profound turning point. In my address at the funeral, I publicly declared that Transkei was willing to hold a referendum to determine if its people wished to remain independent or rejoin a democratic South Africa. Parallel to these political developments, we were approached by religious leaders from the South African Council of Churches, led by Bishop Dlamini of the Anglican Church and Reverend Mzamani. They pleaded with us to intervene and halt the executions of ANC and MK operatives who had been sentenced under the previous regime. After careful consideration, we resolved to institute a moratorium on the death penalty, declaring that no person would be executed until a new democratic government came to power, whether in Transkei or South Africa. On 11th January 1990, it's an interesting part, F.W. de Klerk, then President of the Republic of South Africa, descended upon the Transkei accompanied by his Minister of Foreign Affairs, Mr. Pik Botha, and a full battalion of journalists in a tense and protracted meeting, de Klerk demanded that we disband the military government and return to the barracks so that a civilian administration could take over. This demand was not made in good faith, but rather reflected Pretoria's ongoing interference and its discomfort with a government in Transkei that refused to bow to the apartheid authorities. We refused outright. We reminded him that our removal of the previous government was not done with the South Africa's government's consent, nor did we seek it. Our position was clear. Transkei had declared independence under a different premise, and the people of Transkei had to determine their own political future. President de Klerk expressed displeasure over our political direction. One, he was unhappy that we had proposed a referendum about rejoining South Africa. He condemned our moratorium on the death penalty, which we had instituted to save the lives of many liberation activists unjustly sentenced under the Matanzima regime. He objected to our decision to unban 33 organizations, including ANC and PAC, which we allowed to operate freely in Transkei. He was disturbed by our open door policy to ANC leaders and supporters, which allowed them a safe haven from state-sponsored violence in other parts of the country. That meeting lasted 4 hours and ended in confrontation, with de Klerk storming out, frustrated, exposed, and politically outmaneuvered. Later that same year, towards the end of 1990, these tensions culminated in an attempted coup that was directly sponsored by Pretoria, a calculated effort to destabilize our government and release and reassert control over a territory that has chosen to stand with the forces of liberation. The coup, however, failed, reaffirming the strength, unity, and resolve of the then Transkei military leadership to defend its sovereignty and commitment to justice. In 1990, political tensions intensified further. On the 11th of February 1990, Nelson Mandela was released and liberation organizations were formally unbanned in South Africa. However, what followed was the onset of the so-called black-on-black violence, particularly in Johannesburg and surrounding areas. Media reports portrayed these clashes as ethnic violence, that is between Zulu and Xhosa, IFP versus ANC. Visual distinctions were made: red headbands for IFP, while white headbands for ANC. It soon became evident that the IFP-aligned groups were being escorted by yellow Casper's vehicles, often associated with the South African police. This was not spontaneous violence. It was engineered, orchestrated, and sustained by elements within apartheid security structures. The violence grew so intense that mortuaries were overwhelmed. As a result, I had to authorize buses to retrieve the bodies of deceased Transkei citizens and return them home for burial. This was one of the most traumatic and heart-wrenching responsibilities I carried as head of government. In response, a high-level delegation of ANC leaders sought an urgent meeting with the Transkei leadership in Umtata. We met at Nkululekweni residence the former residential state house used by the then Prime Minister of Transkei. Delegation included the following: O.R. Tambo, the then president of the ANC, Nelson Mandela, Walter Sisulu, Governor Mbeki, John Kadimeng, Elias Motsoaledi, Ahmed Katrada, Raymond Mhlaba, and Andrew Mlangeni, collectively known as Rivonia Trialists and ANC top leadership. They met with me, Brigadier Matanzima, Colonel Mgwebi, and Lieutenant Colonel Zwaiba. The key agenda was the source and intent of the so-called black-on-black violence. After hours of deliberations, we concluded the following. F.W. de Klerk's action were not sincere. His release of political prisoners and unbanning of organization was not a step towards peace, but a strategy to fragment and destabilize the liberation movements. 2, the violence was orchestrated. It served to portray the ANC as a violent entity and discredit its moral authority. ANC leaders re-entered South Africa unarmed under the assumption that the transition would be peaceful, but the state had not disarmed its own agents and proxies. This was a trap, a provocation designed to weaken the ANC and other liberation movement, disrupt negotiations, and ensure that de Klerk maintained his grip on power. De Klerk's real ambition, we believed, was to retain control of South Africa's post-transition by manipulating the terms of engagement while maintaining white minority economic dominance. The violence that had begun in 1990 continued unabated through 1991, intensifying both scale and brutality. The so-called black-on-black violence, which was in reality a carefully orchestrated campaign, was causing devastating loss of life, particularly in urban townships such as those in Gauteng. As these tensions escalated, the OAU, that is Organization of African Unity, convened and passed a critical resolution. The OAU resolved that it was necessary to send independent monitors to South Africa to observe the political violence and to ensure that the country's transition towards democracy was not derailed by internal destabilization or manipulation.
Sorry, Mr. Olumisa. Mr. Sakela, seeing that the statement is before court and is quite detailed, and we get the context so far, would you mind if Mr. Olumisa would skip to the part dealing with what is an issue in these proceedings, the murder of Goniwe and others?
Okay, my lady.
Especially that now this covers a period after the demise of the four.
Thank you. The murder of Goniwe and others is my next topic. It was around 1992 or 1993 when I received a call from Colonel Lawrence du Plessis of the SADF, based in Port Elizabeth. At the time, he was serving as a liaison officer between Transkei Defence Force and the South African Defence Force. He was based in the Eastern Cape Military Command and had previously been instrumental when we needed to send troops abroad for training. However, the reason for his call on this occasion was for more sensitive was far more sensitive and deeply political. Lawrence said he urgently wanted to meet Mr. Nelson Mandela. He explained that he had two pressing matters to raise with him. The first was a personal issue involving the destruction of his chicken store in Alice by local ANC-aligned structures. And the second was a far more serious claim. He alleged that there was credible evidence of the existence of a third force operating under the directive of the apartheid state. According to him, what was commonly referred to as black-on-black violence was in reality violence being sponsored and directed by elements within his own government. Lawrence came down to Mthatha to meet me in person. During our meeting, he handed me a signal and a small brown envelope, which he said contained proof of his claims. I opened it and found a half-a-page signal from the South African Defence Force written in Afrikaans. The content was chilling. The signal slated in deliberately vague but unmistakable language that Matthew Goniwe and others were to be permanently removed from society. The signal was clear. It was a directive for their assassination sanctioned at highest level within the state security structure. Regarding recognizing the gravity of this document, I immediately arranged to meet Mr. Mandela. I flew to Johannesburg with Lawrence. While Lawrence traveled from PE, we met with Mr. Mandela at the Carlton Hotel. During that meeting, Lawrence first spoke about the destruction of his store in Alice, and then proceeded to give Mr. Mandela a detailed explanation of the SANDF signal and what it truly meant. Fortunately, Mr. Mandela understood Afrikaans better than I did, and was able to immediately comprehend the full scope of the message. After that, after the meeting, Lawrence departed, and Mr. Mandela turned to me and instructed that I must not take the document to Shell House as I proposed then, even though I had suggested that we informed Mr. Jacob Zuma and Joan Tlantla, who were in charge of intelligence, who were both based at the ANC's head office. I followed Mandela's instruction and kept the signal to myself for 3 months. During this period, Mandela repeatedly asked to see the document again, carefully reading it. Each time, he understood that this was a vital piece of evidence that proved the apartheid regime was negotiating in bad faith while secretly orchestrating violence. The document confirmed suspicions that the so-called black-on-black violence was not organic, but rather a strategic campaign to destabilize black communities and derail the negotiation process. Eventually, during one of the most volatile periods, when political violence had intensified, Mandela called me for a discussion on how best to release the signal to the public. He had made up his mind that the truth must be revealed. He contacted Zwelakhe Sisulu, who was then the editor of the New Nations newspaper, and gave him clear instructions to leak and publish the signal. The objective was not only to expose the state's duplicity, but also to inform the broader public and international community that while the apartheid government claimed to be committed to peace, they were simultaneously engaging in a covert war against our people. Mandela also instructed Zwelakhe Sisulu to work closely with me to ensure the signal's background and significance were correctly presented. I worked with Sisulu and later with respected journalists, his colleague Jimmy Siepe and Enoch Sithole of the New Nation. They approached the matter with professionalism and care, and their work was exemplary. When the story broke, it quickly gained traction. Other media houses picked it up, and soon the story was carried across multiple newspapers throughout the country. The apartheid government denied everything, rejecting the authenticity of the signal and dismissing the allegations. But the truth had already taken root. Yes, later when the TRC, Truth and Reconciliation Commission, was established, more revelations came to light. The TRC archives confirmed that the state had in fact been involved in orchestrating violence through clandestine operations. Numerous individuals who had worked within the state security apparatus came forward to testify and apply for amnesty. These were the very people who had implemented the state's violent strategies. They included colonels, brigadiers, and other high-ranking officers. By testifying at the TRC, they hoped to avoid prosecution, effectively confessing to crimes that directly contradicted the previous denials by the state. The TRC also uncovered an assassination plot against me. A group had been mobilized and found in possession of large caches of arms. They were intercepted by the Transkei security cluster then, and it was confirmed that their mission was to eliminate me. Their failure was due to vigilance and good intelligence, but the very existence of the plan underscored how far the apartheid state was willing to go to protect its interest and silence those who stood in its way. The TRC files contain these testimonies and documents which provide clear and irrefutable evidence of how state institutions were used to wage a covert war under the cover of negotiation and reconciliation. You want me to continue?
Yes.
In
Mr.
conclusion,
Sakela?
Yeah.
in conclusion,
In conclusion, you can just finish up.
Okay.
Then we go back to,
thank you.
yes.
In closing, my testimony is not offered in search of sympathy or praise, but rather as a solemn and of remembrance and responsibility. It is a tribute to those who were murdered, silenced, or made to suffer in the margins of a violent and deceptive system. It is also a reaffirmation of the vital importance of preserving the truth in our historical record. This account exposes the calculated and well-orchestrated sabotage by the apartheid state, including its use of intelligence structures, covert operations, psychological warfare, targeted assassinations, and manufactured conflict disguised as black-on-black violence, all intended to stall and delegitimize the struggle for liberation in South Africa. The Transkei administration, despite its imperfections, made a conscious and costly choice to stand on the side of justice. We did so under the constant threat facing enemies who sought to maintain the apartheid status quo at any cost. We resisted, not only with words, but with action, protecting leaders, exposing hidden plots, and confronting the lies designed to divide our people. Thank you.
Thank you. Thank you, Mr. Olomisa. In this statement, there is a lot that you have covered that we will not be going through it in the main statement, but we will deal with those silent features of your statement. But I would like to take you to paragraph 32, page 10 of the main statement in the bundle. Page 10 of your statement, paragraph 32. There you are dealing with a letter that you addressed on 7 May 1992 to the then President F.W. de Klerk, and you indicated the purpose of that letter. And that purpose is discussed in detail in paragraph 33 and what it meant. But to make life short for you and also for the court, I would refer you to annexure BHH4, which is the actual letter. And I would like the words in this letter speak through you, because you are the author of this letter. Okay, can you take the court to this letter, please?
So what page is that?
It's page 44, sorry, my lady. Page 44, it's annexure BHH4. Exhibit J for the record.
Thank you.
You want Mr. Olomisa to read the whole letter, word by word?
I think we can say the letter, it is summarized in the statement, but he is comfortable to read it because when we discussed, we felt that it would be better for him to place it on record, my lady. I don't know whether it would be too much for the court or we just go to the summary of the letter, which we are comfortable to do so.
If it's covered sufficiently by the summary, I don't see why the letter should be read word for word.
Then, okay, let me take you to the summary of the letter in paragraph 33. Paragraph 33, my lady.
Of the statement.
Of the statement.
Thank you.
At paragraph 33, you are indicating that the letter disclosed a premeditated murderers that occurred through in Cradock 4. Sorry, page 10, sorry. Page 10.
Yes.
Yes, paragraph 33.1. That's where you summarized the import of the letter. There you are dealing with that the letter, the murderers of the Cradock 4 were deliberate and premeditated. What is your view about that? What is your comment about that? What did you mean to say that?
Well, it was based on the signal, which was in the public domain at that stage, and where the signal were identified and confirmed that its authenticity, that it came from the State Department of Defense, signed by Colonel du Plessis on the instructions of his superiors.
Then you indicated that you linked this with the involvement of the apartheid government at paragraph 33.3, that the National Party was involved behind these killings. The apartheid government was the perpetrator.
Well, the the results or the testimonies at the TRC prove beyond reasonable doubt that this violence was sponsored by the state of apartheid.
Then you also called the then President F.W. de Klerk to account about these criminal acts at paragraph 44 or 33.4. Then what did you want to achieve by calling him to account publicly about it?
Is because when the people of South Africa were accusing the government of de Klerk that it is behind the violence at the time, they kept on denying, even on this issue of this signal. They still felt that this was a propaganda against them. But the evidence which was led later in the hearings of the TRC and also for those who were applying for amnesty proved beyond reasonable doubt that the state was behind the violence. And that I was saying to President de Klerk, if you were not informed, you were not aware that your troops or your security is doing this dirty work, you should prosecute them. Why do you just issue a statement to say you are not involved? Yet there is proof.
So F.W. de Klerk had the capacity, or the apartheid government should have prosecuted these people even way before the TRC.
Yes, if they have done something wrong, because we have never heard in their laws that they have a power to take lives of other people.
Then also the purpose of the letter to him, you wanted to elicit an official response. Did you get any response from the apartheid government
No,
about this?
no.
Then let us go to, you indicated in your statement about the signal, you indicated that the meaning of what was contained in the signal, how it was interpreted. And this interpretation, is it the same interpretation that we get it from the New Age? Can you go to page 51? Page 51. It's
51.
Annexure BHH5, the New Age article.
Okay. Yes.
Page 51. The article, although it is in Afrikaans, but I'm worried whether you'll see because it's too tiny, the thing, the writing there.
Yes,
But you will see there, it refers to 3 people that should be permanently eliminated. It's Matthew Goniwe, Mbulelo Goniwe, and Fort Kalata. Those were the people that should be eliminated according to the signal. Do you see that?
Yes.
Then it makes a reference to PEPCO 3, that whatever that happened in PEPCO 3 should not repeat itself here because there will be going to be suspicions. What is your take on that?
That simply implies that the authors of this signal were aware how the PEPCO 3 were killed or eliminated. And for them to say, make sure that these ones, if we do this work, it must be a clean work, so that we are not, it's not associated with the others who were eliminated. That's my poor interpretation.
No, that's a clear interpretation.
Mr. Sakela, do you know whether there's a clearer copy, maybe with a bigger print of this
Yes,
signal?
my lady, this copy, I can take you, it's properly interpreted in the annexure that we have attached Annexure, let me just take you, my lady. The findings of Zitzman,
But insofar as the document itself is concerned,
or
you
the
don't
document, I
a
do not
better
have a
copy.
bigger interpretation. Page 33 of this. Yes, this one is Afrikaans. I wanted the English one. Yes, there is a bigger one, my lady, which is page 33, but it's in Afrikaans. But we do not have a bigger version where there is also an interpretation.
No, that's okay, just wanted the one with the, oh, I see it now, thank you.
Yes.
Yes,
Page 33 is bigger, but it has and it's in Afrikaans one. my
thank you.
Yes. Thank you, my lady. Then the signal makes a reference to the permanent removal of these three people from society. What is your understanding of permanent removal?
The understanding I have on that, it means that these people must be killed permanently, because you can say, for instance, where you would argue, say, we want to remove these people from PE to another region or detention, but you can't use the word permanently. Permanently should mean remove them permanently
Out of the society.
from society. Where else are you going to keep them?
And that understanding is in line with what was the finding of the Judge Zitzman. And I will take you just to show that your understanding is correct and it's aligned with the annexure. Annexure BHH 3, my lady. BHH 3, pages, let us go to page 38. Page 38. Page 38. Then page 38, the paragraph that starts with the word I will read it. I have considered, that is the finding of the judge who was doing the inquest at that time. This is the reopening of, this is the third inquest. I have considered Colonel du Plessis' evidence and Mr. Mostert's criticism thereof. I have looked carefully at the wording of the signal, and I have also considered the evidence given by General van der Westhuizen, by Major General van Rensburg, and by the other witnesses who testified. Let me just skip to the last sentence. It has, however, in my opinion, been prima facie established on the evidence as a whole that the meaning Colonel du Plessis intended the words used by him in the signal to have in the Matthew Goniwe, Mbulelo Goniwe, and Fort Kalata should be killed. That is in line with your understanding. Do you agree?
Yes.
And we have, my lady, examples of that finding in the paragraph that follows, where the justice indicated that that signal meant killed. So there is no argument about what it meant. Can I take you, my lady, to paragraph 40, your page 40 of the same, the last example that I want to draw to your attention, so that to align your evidence, your understanding of the signal. There at page 40, last sentence, in my opinion, it has been established prima facie that the signal was intended by Colonel du Plessis to mean that Matthew Goniwe and the others should be killed, and also that this is the meaning that Brigadier van der Westhuizen intended should be conveyed to the signal. So that means Because these people are claiming, even on the transcript of the TRC and everyone, they are claiming that they were instructed by General van der Westhuizen. Do you know General van der Westhuizen? Have you ever seen him?
Yes, I know him. He was the commander of, or the OC, or whatever term you want to call this, commander of the Eastern Cape Command. Very capable officer. In fact, at that time we were saying there was a lot of talk that he might be the future commander of the SADF. Very clever, young, like he was still at his early stage at that stage. Yes, I know him. I know him because Transkei had a bilateral arrangement or agreement that Colonel Du Plessis would arrange meetings between us and the Eastern Cape Command, in particular when it comes to issues of training. When we got into power, we changed the rules and we said we are not going to send our troops to the so-called black military bases for training, but we'll send our officers to train with the white South Africans in their institutions. So that's why you'll find that a number of our officers were doing staff courses with white South Africans in their institutions.
Then, before this incident, you got the signal. Did you know Matthew Koniwe and Mbulelo Koniwe and Fort Kalata and other Cradock 4 members?
I knew Matthew Koniwe because he was a teacher in Transkei at Holomisa High School. And he used to visit his friend as well at Jongilizwe College while I was doing my matric. His friend was none other than Advocate Dumisa Ntsabeza. So I knew him.
Then did you know his political involvement or political dealings?
Well, unfortunately, Dumisa Ntsabeza and for them and Koniwe, they were in and out of prisons, being detained by the security forces of Transkei. And I think at one stage they were charged.
And sentenced, yeah.
And sentenced.
Yeah, we have that evidence that at some stage they were charged and they were sentenced, and Matthew Koniwe served several years in prison. Then your knowledge of Van der Westhuizen has nothing, does it have anything to do with the murder that took place on the 27th of June, or nothing at all?
No, that one was very far away from me.
Okay. So you do not have an independent knowledge of the incident itself. Thank you. Let me just a few things to cover up. My lady, I'm not going to take Mr. Holomisa through his statement because he provided a summary through what he was reading. The detailed statement, it's clear, and I do not want to waste the court's time and the time of the minister.
So
No, just one thing, So you indicated, and this is what was said by Mbulelo Koniwe yesterday, by Mr. Koniwe when he was testifying, that the killing of the revelation of the signal relating to the killing of the Cradock 4 propelled, he said it was a huge setback, but that it propelled the negotiations. What is your view on that?
There is no doubt about that. You will recall that, if my memory serves me correct, after the Boipatong massacre, the negotiations were suspended. And later on, Mr. Mandela called me, I think twice. I flew up to Joburg with that signal because it was in our hands at that time. And he looked at it. And his aim was to expose the apartheid government, that it is behind these massacres which were taking place, especially when you saw that there were certain people who were led by yellow Caspers or escorted by yellow Caspers, which belonged to the South African Police Service then. So Matiba then, we discussed it, and then we said, let us release this. This is time now to expose de Klerk, especially that the newspapers did their own research and confirmed that President de Klerk was a Minister of Education at some stage under P.W. Botha, was part of the Security Council, was a member. So in that way, then we said, if he was a member of Security Council, that war machinery, so his mind is still continuing with the elimination of black South Africans. So that signal, therefore, changed the trajectory completely. And as a result, as I said, if I'm not mistaken, about the dates, the OAU resolved that they should send monitors to South Africa to monitor violence. I also had the privilege of accompanying Mr. Mandela to United Nations to address Security Council. We discussed the issue of, to present the case of South Africa on the issue of so-called black-on-black violence. Mandela, Tatuma Kwetu of the PAC, Philip Mahlangu of Kwandebele, and myself, we addressed the Security Council. Pigbota, Mangope, Buthelezi, and others, Gozos, they were on the other side, saying there's no need to send the monitors to monitor violence in South Africa. So, in all, the signal, when it was published, it helped the negotiators to pressurize de Klerk. No doubt, Mr. Koniwe is correct.
My lady, that piece of evidence is also contained in from paragraph 29 of his statement to paragraph 31. So from paragraph 27 to paragraph 31, my lady. That is a summary that he has given. Then the last point, you indicated that there was a stage where you were going to be assassinated. You gave a brief summary in your statement, but you went into detail in the main statement. Then what was the reason for your elimination vis-a-vis the conduct of the apartheid government when it's confronted with the people who were dealing with its objective or its purpose?
Well, I think after F.W. de Klerk went to Mthatha in 1990 to go and instruct us to hand over power to civilians, and then we rejected him. He never recovered from that. A Bantustan can show him a middle finger. So they started to destabilize Transkei and recruited people to be trained in areas like Queenstown And then in 1990, towards the end of 1990, they staged that abortive coup. Amongst the people who were involved in that coup were members of LLA, Lesotho Liberation Army, one of those rogue elements which were used to destabilize neighboring countries. But they failed dismally. So then they tried to flag plus, yes, flag plus under Eugene de Kock, sent emissaries or dispatch people to go and conduct these assassinations. But fortunately, we also invested. Because intelligence, you don't just listen to your own people. We also invested amongst the people who were keeping us informed, and we intercepted almost everything. So TRC report is there. I don't want to waste time of the court.
Yes.
People were there to ask for amnesty. And I said to them, no, enjoy.
Then you mentioned a number of people from paragraph 39 who were part of the State Security Council, paragraph 39, page 13, my lady.
Yes, of course.
Yes, and also you mentioned some at paragraph 45. And you say, in respect of all these people, nothing was ever done to prosecute them for being involved or planning the murder that took place at Cradock 4.
Not only for Cradock 4, but the rest of the people who went to apply for amnesty. We were surprised that they went to apply for amnesty after their bosses were saying, no, they are above board, there's no such thing. But they went to apply for amnesty using state equipment, using state weapons. So no one was charged, even today. I'm sure there are about 2 or 3, if I'm not mistaken.
Others died
Yeah.
without being charged. Then what is your view that after the TRC, nothing was done in respect of these people, those who admitted?
Will be that of assistance to the court in arriving at the requisite findings, Mr. Sakela?
No, my lady, let me leave that question.
I agree with you, my lady.
Yes. Then, my lady, we have already dealt with the black-on-black violence, all the headings, communication of the signal, the structure and framework. Then, can I take you to the conclusion which is contained at paragraph 69, page 22? Can you go to that conclusion, Mr. Ogamisa? Sorry, page 22.
Page 22.
There at the bottom, there is a divider. Can you go to the divider, sorry?
Yeah?
No, the yellow one. Yes, take
This
that
one?
one. Yes, your statement is under that divider.
Oh, yeah, okay.
Yes.
Sorry. Page 22.
Yes,
Yes?
yes.
He wants you to read the conclusion.
Can you read the conclusion?
Okay. The evidence I have provided herein demonstrates that the deaths of the Cradock 4 formed part of a deliberate and systematic state policy of elimination of political opponents. The highest structure of the apartheid government were involved in authorizing these killings. I stand ready to assist the Honorable Court further should it requires clarification or elaboration on any of the issues raised herein. I think I've already done that.
Yes. My lord, my lady, that is his evidence.
You can rest assured that more clarification will be required by the representatives. So you shouldn't be in a hurry to leave us just yet. Mr. Coltman, any questions? Yes, Mr. Governor?
The state has no questions for Mr. Olumisa, except to thank him for availing himself today to assist us.
Thank you, Mr. Governor. Any questions, Mr. Vani?
Yes, my lady.
We just want to put certain documents to the Deputy Minister. We need just a few minutes to collect these documents. Would this be an opportune moment for the morning tea break?
We'll adjourn for 15 minutes.
As a court please.
Yes, Mr. Vani?
We were just negotiating at some stage, maybe during the cross-examination, Mr. Wolomisa would require an interpreter. If that time comes, he will indicate. So I just want to place on record that there will be a need at some stage of that.
Thank you. I'm sure you don't need an interpreter, Mr. Olomisa, to be reminded that you are still under oath.
No, not now.
Yes, Mr. Vani?
Manali, before we commence, with the leave of the court, I'd like to hand up a hard copy of Volume I, which we added to the record over the past few months. I'm not sure whether your ladyship has a hard copy.
No, I don't.
Okay. Thank you.
Thank you. Nkosi.
My lady, just so that the court is aware where we're going, we want to... Yeah. We just wish to canvass with the Deputy Minister a document titled Press Conference at the Holiday Inn, Port Elizabeth, which took place on the 11th of March 1993. My lady, that is in fact in Volume I. We've just handed up from page 162. We've flagged it for your ladyship. And we will also be making reference to the Zietsman judgment. And my lady, that's in Volume H. And the page in particular we'll focus on is 272 of Volume H. Mr. Holomisa, if I may refer to you as Mr. Holomisa, yes, as opposed to General or Deputy Minister. Firstly, thank you for taking time out of your schedule to be with us today and to assist this court in getting to the truth. And on behalf of the families of the Cradock Four, we'd also like to thank you for your struggle in trying to get to the bottom of political violence and machinations that took place in the 1980s and also into the 1990s. The work that you have done in this regard is recognized by the families. Mr. Holomisa, can I take you to this press conference? And I understand that you have a copy of the statement you made at the press conference at the Holiday Inn in Port Elizabeth on the 11th of March 1993. My lady, that's page 162 at Volume I. It's got a purple flag.
Yes.
Before we look at your statement and the supporting documents, can you just explain to the court why you called that press conference on the 11th of March 1993?
1993. You know, I'm old now. On a serious note, it was more to expose the destabilization program by the government of National Party, and even to the extent of wanting to us as Transkei to fight with Ciskei, like another black on black violence. And also I revealed on that day that the word permanent and removal seemed to have been a common word which was used when you want to remove somebody. So I was referring to the plan to remove L.L. Sebe, who was the president or prime minister of Ciskei, and that this was going to be staged by the advisors of Transkei Defence Force, namely Reed Daly of the then Rhodesia, who was advising the Transkei Defence Force at the time. And they met in Lusigisigi, for instance, and we got the information and minutes and so on. I think I attached those during that time in the press conference. So it was more exposing de Klerk's plan to destabilize the Transkei and Ciskei with the aim of having control in that region.
Right. Thanks for that background. We're going to get to the documents you attached to your statement, but can you just advise the court where those documents came from, who passed them on to you?
The documents were passed to me by Colonel du Plessis, because after we met with Madiba, he said he's got more files. Then he handed those files to me. I kept them, and I handed over those files, including the signal, I think to the TRC. I've got none now, nothing.
Probably best that you have nothing anymore. Mr. Kgalemisa, Colonel du Plessis, is this Colonel Lawrence du Plessis, who was formerly with the South African Defence Force,
Yes.
based in Port Elizabeth at EP Command?
Yes,
And is he the same Lawrence du Plessis who, under the instructions of former Brigadier Joffel van der Westhuizen, sent the infamous permanent removal signal to the Secretariat of the State Security Council?
same.
Thank you. Now, do you have a copy of your statement? I think we provided one to
Yes.
your team.
Yes.
I will be referring the court to the page numbers in volume I.
Okay.
I don't know whether we did give you a copy with,
Yes, of
with the
course.
page numbers. And perhaps if I can refer you to page 6 of the statement, and my lady, that's page 168 of the record. And in that middle paragraph, can I just ask you to read into the record that middle paragraph starting on 10 November 1986?
Okay. On 10 November 1986, the following army officers met at Msikaba military base in Lusikisiki, Transkei. General Reed Daly, the advisor to the TDF, that is Transkei Defence Force, General Charles Sebe, Chief Number Sebe, Brigadier van der Westhuizen, Colonel van Rooyen, and Major V.D. van der Merwe, of SAP. See the document marked C. It was confirmed that phase 1 has been implemented. For example, Charles Sebe was out of jail. Lennox and Kwane Sebe must be permanently taken out or removed. The minutes of this meeting were conveyed to Chief of the SADF via Colonel L.D. More.
More, M-O-R-E.
Yeah,
More, yeah.
more in Pretoria. See the document marked D.
Thank you. Now, a little low on that page, you draw a comparison between the words take out, and you say this is a common jargon that has been used. What did you mean by that?
I was looking at these words because in the signal they use remove people permanently from society. In this particular one, they are also using the word take out or removed. The attempt was made on Sebe's life on that particular operation. They had also used force, if you remember, when they removed Sebe from jail, that is Charles Sebe.
Thank you. And in the middle paragraph of the next page, you talk about the strategy of pitting black against black. Can you just elaborate what you meant by that?
If you follow what Ciskai's operation was and wanting to enforce Ciskai and Transkei to be under one, and that to go to the extent of saying they will remove the Prime Minister or President of Ciskai L7. It meant to me that they were not going to negotiate this merger, but they were going to use force. So impliedly, if the Ciskai people were to be removed by people who are from Transkei government or Transkei Defence Force, like in the case of Reed Daly. So it could easily be interpreted that you let the Xhosas fight another Xhosas, so black on black violence.
Thank you. And if I can refer you to the top of page 9, which is 171 of the record.
Page?
So it's page 9 of your statement, and in the record it's at the top of page 171. And you make an interesting observation. You say, and I quote, "We are, however, very fortunate in this case because some of the ministers who served in the State Security Council under ex-State President P.W. Botha, like President de Klerk, Mrs. Pick Botha, Kubi Coetzee, Adrian Vlok, etc., are still alive and kicking. They will be expected to shed light on the murky activities of their government." Now here we are, more than 30 years later. Did they ever shed light on these murky activities?
Not that I can think of, other than denying all the time.
And indeed, am I right in saying that all of them, including Adrian Vlok, who passed away last year, that they're all dead now?
Yes, they are all dead.
And perhaps we can now turn to some references in these documents. And you have helpfully provided English translations of these various documents. Can I ask who did these translations for you at that time?
The translations might have been done by my legal advisor, Mtatas, Mtatas, or Mr. Mkudlwa, if I'm not mistaken.
Right. And I'm sure my colleagues will look at the translation and compare it closely with the handwritten versions. If there are any issues, they will bring it to the court's attention. So the first document is a top secret document from a lady at Payne Province Command. Under inquiries, there's Brigadier C.P. van der Westhuizen, and it's titled Submission Operation Katzen, and it's addressed to the Chief of the SA Army. And if I can refer you to page 184 of the record, it's page 11 of that document. And paragraph 5 at the bottom of that page. I'm just going to put a few passages to you and ask for your response, Mr. Khulumisa. So paragraph 5 at the bottom of page 11. The big stumbling block is Lennox Sebe, and therefore he must be removed as a step of this phase or even earlier. And then if we turn to page 15, 188 of the record, paragraph 17. Lennox Sebe has for a long time been an embarrassment to the government, as the State President has himself said so. He will be got rid of with the implementation of this plan. So, what is your take on what is being expressed in those paragraphs?
Well, it tells you that the government of South Africa, if they don't want you or like you, they will use any means to remove you.
Right. Then let's turn to the next document. I'm going to skip the handwritten version. The next document you attached is on page 216 of the record. It's also a top secret communication from Brigadier C.P. van der Westhuizen to Chief of the Army. It's dated 13 June 1986. It's titled Submission Plan. And actually the references in this document are quite similar, so I'm going to skip that one just to save time. And let's now turn to what's probably the most important document that you attached to your press statement. The lady in the records from page 257. And we're going to look at the translated version and original minutes of a meeting held at Msikaba military base Transkei, the 10th of November 1986. It's a top secret minute. It's titled Report with respect to discussions held at Msikaba between General Reed Daly, General Sebe, General N. Sebe, Brigadier van der Westhuizen, Colonel van Rooyen, Major van der Merwe, SAPV, on the 10th of November 1986. And can I ask you to read in the record the 4 phases that are listed under paragraph 1C. If you could just read phase 1A to D, please.
Okay. The 4 phases are: phase 1, hard military phase. Under hard military phase is, you've got A, Charles Sebe out of jail, gets 3 sons out of jail, not succeeded. Kwane Sebe take out, in inverted commas. He is dangerous, and he shall take over from Lennox Sebe. Lennox Sebe must be permanently removed. Next, military alliance between Ciskei, Transkei, and RSA risen.
Actually, Mr. Khalimisi, you can pause there.
Okay.
And if we can then turn over the page
Okay.
to page 4.
Yes, I must read it.
And you can read priority 1 and then the first line of the second paragraph.
Priority 1, is it 4?
It's under F.
Page 261.
It's page 261, page 4, perhaps in
okay.
your statement.
Okay. Priority 1. Lennox out. This is not, or this is and remains main aim. Need not take place first. Number 7 must disappear from the scene. Yeah. SAP cannot then act against him.
And if we can then pause there and turn over the page. And perhaps I'll just read this to you. Paragraph 4. Opinion of members. Lennox to be taken out, e.g. Colonel Zibi. paragraph Roman numeral 5. Kwane Sebe and his twin brother must never return to Ciskei. If the situation improves, this can be reconsidered. In case they are not locked up forever, they must disappear. And then paragraph 7, when Lennox disappears or gives way, there must be a government that can take over to prevent a new leader from emerging. So this, the meetings, the minutes of this meeting at this military base, in a nutshell, what was your view? What were they attempting to do here?
Well, they've said it themselves that they will use military to effect this operation. And for them to use such words as to say they must not return back to Ciskei, they must disappear, is clear. What method were they going to use? Where were they going to keep them? Because I don't think Sebe would have gone to exile. No other country would have accepted them.
Okay, Mr. Khalimisa, let's now turn to one of the last documents we're going to refer to. It's under reference D of your supporting documents, from page 265 of the record. And in the translated document, it's a record of discussions between General Reed Daly, General Sebe, Chief Namba Sebe, Brigadier van der Westhuizen, Colonel van Rooyen, and Major van der Merwe at Imsikaba on 10 November 86. And if I can ask you to turn the page. Can I ask you to read paragraph E?
Okay. Colonel Zibi must disappear, in brackets, permanent. Just permanent.
Permanent, exactly. What did you take the disappear permanent to mean?
Well, there's no other definition other than to kill those people, or this colonel.
Now, if I can ask you to turn to page 271. There are some press clippings there.
Yes.
And it turns out that there was actually action taken against Lennox Sebe. Can you just read the title of that Daily Dispatch newspaper piece?
It says, pre-dawn assault was a coup attempt, Ciskei.
Yes. So just in terms of the timing, for example, the meeting at Imzikaba, that took place on the 10th of November 1986. And the Daily Dispatch article is dated the 21st of February 1987, so just a few months later. Can you just explain what this pre-dawn assault was about?
Well, it's clear that they were effecting their plan, which they hammered in Musigaba and Lusikisiki in 1986. So what happened then in 87, they were effecting that plan. You can't give it another name because they had phases. So this must have been the implementation of a phase to remove Sebe.
So did you make a connection between these meetings in taking out, well, in Lennox Sebe's case, permanently take out, did you make a connection between those proposals and what happened at his home in early 1987?
Yes, it's clear.
If I can refer you to the judgment of Zitzman, Judge Zitzman.
Page?
So what's the page? I believe it's page 272 of the record and page 46 of the judgment.
270. It's not on here.
I think the judgment is that small A5 one that's on top, yes.
This one.
So if you can go to,
271.
it should be, I think, 272. That's of the record. The page number of the actual judgment is 46.
Yeah, I've got.
Yes, how come I'm not with you, Mr. Vani?
I beg your pardon, milady. We're now referring to the judgment of Judge Zitzman in the Zitzman Inquest. The judgment is not in volume I, it's in volume H, at page 272. Does milady have volume H with her?
Nope, I don't.
Okay. We have asked copies of that extract to be copied, and one of my attorneys is busy copying it now.
All right. Isn't that the parts that Mr. Sakela referred to? They referred the witness to earlier?
It's actually a different passage, milady.
All right.
But we will read verbatim the extract. It's not particularly long.
Assistant lady, it's also part of the statement of annexure to Mbulelo Goniwe's statement. You can refer to the page number, the typed page.
Okay, what page number?
In Mbulelo Goniwe, it starts at page 64. The judgment is at page 64, annexure MTG 1. Then I would request my learned friend to use the typed page so that you can be able to follow my lady.
Can you just remind us of the page numbers in the Mbulelo affidavit?
Mbulelo is at page 64. Page 64,
Just put it down here.
annexure MTG 1, page 64.
And it's at page 109 of the record, milady.
Thank you.
I'm indebted to my learned friend. So, Mr. Kholomisa, do you have the correct page in the Zitzman judgment?
I don't think so. I'm at 272.
272, yes, that's correct.
270.
If
Is
you
this
can
one?
go to 272, it's page 46.
Page 46, yes.
Okay. I'm just going to read you some extracts. So in fact, Judge Zitzman refers to that meeting that was held in Imzikaba on the 10th of November 1986. And he starts with the statement, in my opinion, more than one of these options contemplate the possibility of Lennox Sebe being murdered. One of the documents is a report of a meeting held at Imzikaba on 10 November 1986, at which Brigadier van der Westhuizen was present. The document contains the following statements. Kwana Sebe Eital, hy is gevaarlig, en Selbe dan Lennox Sebe oorneem. Lennox S moet permanent uitgehaal word. Another document, the following appears. Colonel Zibi moet verdwyn permanent. Are you familiar with this Colonel Zibi?
No.
No. So you don't know what ultimately happened to him. Okay. So in conclusion then, Mr. Khalamisa, do you see a relationship between the words used in the signal that Brigadier van der Westhuizen authorized Colonel Lawrence du Plessis to send to the State Security Council Secretariat as in permanently disappear from society with the words used in these Operation Katzen documents?
My lady, with respect, I've been very patient, but what will this answer of this witness, who is a layperson in this regard, assist your ladyship to come to a conclusion or to make findings relating to the present question before your ladyship? I don't want to waste time with a long argument, but with great
Is the
respect.
question not whether he recognizes the similarities between words used in
You
both?
can see the similarities. You are the person who must interpret it insofar as it is necessary and relevant for the present inquiry before you.
Mr. Vani?
With respect, my lady, my learned friend refers to the witness as a layperson. He's hardly a layperson, he's a Major General. He was the head of the Transcar Defence Force. So that suggestion is completely and utterly without foundation, my lady, and this witness is
Without
eminently...
debating the matter any further, I don't think the witness was called as an expert, because that will also come into play. So let's not go there.
Yes, my
He's
lady.
not been qualified as an expert in these
No,
proceedings.
lady, I'm simply pointing out that he has had a life steeped in military matters, at least in the past.
And okay, the objection I think relates to the relevance of his view in this regard.
Yes, my lady. We would argue that it is relevant. He is qualified to make this observation and reach his own opinion, which I think would be important for this court to hear.
Okay, carry on.
Thank you.
Mr. Hollis, apologies for that interruption. So if we can get back to the question, do you see similarities between the wordings used in the Cradock 4 signal, permanently removed from society, and in relation to the words used, permanently disappear, in relation to Colonel Zibi and others?
If you follow these minutes as well as the signal to remove permanently from society of Goniwe and others, you will find that these documents, they are traceable. You can identify the institution which was involved. Once it's published or is sent to those units or to the authorities, that then the following few months, those people will disappear from society. In the case of Gonu and others, they were murdered. In this case of Sebe and others, the same words were used. There is a proof that there was an attempt to take his life. Who take this term, who came up with this terminology, is none other than South African government and their security lead personnel. In the case, for instance, of use of violence by de Klerk, you will recall that he raided the North Crest house where the Mpendulo children were killed by the Mpendulo was a member of the PAC. And de Klerk confirmed when I landed from France, when I came back from France on that morning, that yes, he authorized the use of violence, but he hit the children thinking that he was hitting terrorists in that house. So that was in their veins. Let us not argue about that.
Thank you, Mr. Khalamisa. No further questions, my lady.
Any other questions for Mr. Olumisa? Mr. Celia, any questions?
No questions from our side.
Any questions, Mr. Miller?
Thank you, Lady. Mr. Olumisa, Mr. Lennox Sebe, when did he pass away?
I don't know.
I think it was 1994.
94.
1994. Do you agree with me?
I won't disagree with you. You seem to know it better.
And do you know why he passed away? Was it natural causes or
It was natural causes.
causes? So, and you were referred by Mr. Varney to meetings that took place in 1986 with words that he must be taken out or permanently removed. It seems to me it did not happen. Do you agree with me? Because he died 8 years later of natural causes.
No, we're talking about an operation which was planned. Don't twist facts. And we tell you in 1986, these are the minutes which are in part of these proceedings. So why are you introducing 1994? And you saw it here, that attempted assassination or attack Sky was abortive. It didn't succeed. It's here on record.
Yes, Mr. Olumisa, but the objective facts are that apparently, if I interpret your evidence correctly, or what was put to you by Mr. Varney that you confirmed, that those meetings, or that specific meeting, where that was apparently planned, was in 1986.
Yes.
The objective fact shows us that in 1994, 8 years later, Mr. Sebe died of natural causes. He wasn't murdered. He wasn't permanently removed or murdered. That's the objective facts.
No,
Do you agree with me?
You are mixing issues.
I'm talking about the objective facts.
The attempt to take Sebe out was carried out as per plan of 10th of 1986. So it didn't take place.
Yes.
And then there was no other attempt after that I know of. So why are you including 94?
Because that is when he passed away.
No.
But those are the objective facts. I put it to you. I'm not going to
But
take
in
it any further.
1994, there were no Van der Westhuizen in power. There was no Reed Daly. Why do you want to link 94, his passing naturally with that?
The only purpose of that is that's the date when he died from natural causes.
No.
Yes, I think the witness has confirmed that.
Thank you.
Any other questions for Mr. Olumisa? Any re-examination?
Just
Yes.
one question, Your Worship.
All right.
Mr. Olumisa, the question I want to ask you, I shouldn't ask you in this court, am I right?
I know that question.
What is the question? No further questions.
Any re-examination, Mr. Sakela?
Thank you.
All right. Thank you very much, Mr. Olumisa. You may now be excused.
Thank you, my lady.
You've been raring to go a long time ago. Now you can be excused. Mr. Vani, perhaps you can address the issue that you wanted to raise with the court? Or
My lady, that
Yes.
was the evidence of Mr. Olumisa. We have. Oh, sorry, my lady, I didn't hear. Sorry, I apologize.
all
I
right, that's
apologize.
okay. Mr. Vani?
My lady, in consultation with my learned friends for the state, as well as Mr. Mbelela Ganiwa and the community, we would like your ladyship to issue an order that the witnesses scheduled for this sitting in fact testify. A dispute has been raised by Mr. Saliers for the former security branch officers, and Mr. Saliers says that there may be evidence from Mr. Eugene de Kock implicating one or more of their clients. And so therefore, the persons of interest should stand down until Mr. de Kock testifies.
Which is not likely to happen during the course of this sitting.
Well, my lady, the information we have received from Mr. Cox's representatives is that he is ill and is unable to testify. He's even unable to testify remotely. If we'd be happy for him to testify virtually if he could potentially do that. And perhaps a learned friend from Mr. Cock can indicate whether that is still a possibility or not. But if it isn't, we are concerned that we may be waiting forever. We simply don't know whether Mr. de Kock will ever be in a position to testify. And we suggest, milady, that the evidence proceeds as normal. And should Mr. de Kock come to testify at a later stage, perhaps at the next sitting, and if he does implicate one or more of the other witnesses, that they be afforded the right of response, which again could be done by way of a virtual hearing.
Would the right of response include the right to cross-examine the witness?
Indeed, my lord. At least, my lady, indeed. We've also heard, and I think Advocate Governor for the state brought it to my attention that in the medical report, there's a possibility that we may not even hear from Mr. de Kock within the next 6 months, given his state, which would seriously hinder and obstruct this inquiry, because it means that we would be placed on hold potentially for another 6 months without proceeding. And my lord, certainly from the perspective of the families, but I'd also like to hear from my other learned friends that would be most unfortunate and not in the interest of justice to delay this inquest for such a long period. And my lady, we're of the respectful view, although it's not a perfect state of affairs, but we're of the view that the evidence should proceed in the normal course, and should Mr. de Kock testify, that a right of response and a right to cross-examine Mr. de Kock be reserved. Those are submissions, my lady.
I see he's listed in the draft schedule as a person of interest as opposed to just a normal witness.
Yes, we do indicate who is a person of interest, and indeed, with the exception of a few witnesses, most of the remaining witnesses are all persons of interest.
I also noticed that there are investigating officers listed who I believe are scheduled to give evidence. What is the position? When are they scheduled to give evidence?
Well, we had initially thought that they could testify at the next sitting. We felt it important to hear from the persons of interest because of their elderly and sickly state. There's a real concern, and it has happened in other inquests, and indeed in this inquest, that persons of interest have passed on, meaning we will never hear their evidence. So that's why in discussions with our learned friends from the state, we sought to hear from the persons of interest first. Having said that, my lady, we have reached out to the NPA to ask them to determine the availability of the living investigating officers, and perhaps they can respond in due course as to whether they're available or not.
Not knowing what the investigating officers are going to testify about, whether they will be implicating the persons of interest, in line with what I had prima facie indicated, that it is desirable for witnesses who would implicate the persons of interest to testify ahead of them. What would your submission be in that regard regarding the investigating officers now? Although I appreciate that there is no certainty whether they will be called, there still any of them who are still alive, but can you address me on that aspect?
Yes, certainly, my lady. In relation to the investigating officers, we know what the evidence is going to be because we have their statements. And my lady, we took the trouble of extracting those statements and circulating them to all the parties. So, my lady, none of the investigating officers are in a position to implicate these persons of interest. My lady, I'll be frank. We want to hear from the investigating officers as to why this matter has taken so long to resolve. That's certainly the primary interest from the families. Lady, we do consider that in relation to Mr. de Kock, and we don't have a statement from him, so we don't know what his evidence is going to be and whether he will implicate individuals. But we are aware that Mr. de Kock did get amnesty for his role in assisting with the cover-up of the Cradock 4 murders. And so his evidence is set out in the amnesty proceedings before the TRC and available to all my learned friends. In relation to the Cradock 4, my recollection is that he's only in a position to implicate, directly at least, Major Saki van Zyl, who is deceased and will not be appearing. So, my lady, from our perspective, until we get a statement from Mr. de Kock's team, we don't know where Mr. de Kock will be going with his evidence. But in relation to the Cradock 4, it appears that he's only in a position to implicate one of the deceased individuals who was involved in the actual operation itself. So again, my lady, we, in order not to waste judicial time, in order to act in the interests of justice, in order to ensure that the evidence of these very elderly and sometimes sickly gentlemen are placed on the record before they pass away. And I simply point again, my lady, to their advanced ages. And some of these individuals are in their late 80s. Several of them are simply too ill to travel to Port Elizabeth. My lady, the writing is on the wall. The signs are all there. These are people in the twilight of their lives. They could pass away at any time. Already we've seen the passing of individuals such as Eric Winter, Adrian Vlok, F.W. de Klerk, Johan van der Merwe, and others who would normally have appeared before this inquest. And in closing, my lady, we would submit that it's incumbent upon this honourable court to ensure that that evidence is preserved and not lost, and that there are measures that can be taken to protect the rights of the persons of interest, which we have set out.
Thank you, Mr.
Thank you.
Can I hear from Mr. de Kock's representative what the position is regarding Mr. de Kock?
Thank you, my lady. Yes, my lady. As per the previous communication, we received information, I think last week, Friday, that Mr. de Kock attended his medical practitioner, and according to the medical practitioner, it was suggested that he be admitted. My lady, I will request that the entire contents of the medical report, which I will request to hand up to the court, not be disclosed at this stage. And essentially, Mr. de Kock is at this stage suffering from inter alia heart failure, and his medical practitioner advised that he for now at least rest for 2 to 4 weeks. We have had a discussion with the medical practitioner this morning. He said there's a possibility that Mr. de Kock might be able to testify within a month. I can't take it further than that, my lady. I'm not sure if he will, if his condition will worsen or if it will get any better in a month. I can't take it further than that, my lady.
Thank you.
As it pleases.
Mr. Celia?
I think the same was to put on the record, I suppose. I can address you, but I think it will be of much assistance if we know the position relating to the investigating officers, because that might influence our approach and my instructions.
Thank you. Mr. Coltman?
My lady, perhaps I should start with the issue regarding the investigating officer. My lady, it's correct what Advocate Varney had placed before court. All the statements of these investigating officers had been circulated. It is in the record itself. It's part of the record. So everybody has had sight thereof. Our view is that, and especially with regard to more particularly Jonker and Whale that had been listed. Els has already passed away. He was the first investigating officer. So Jonker had also been part of the initial investigation, and later on during the Zietsman inquest, as well as Whale. So their evidence covers everything that had already been considered at the time and had been placed before the court, and even before this Zietsman inquest hearing. So our attitude is we do not understand why it would be necessary for them to come and explain why it took so long for this matter to appear before court again. Because the investigations that they had done it's disclosed in their statements. And Your Ladyship will, but it is also common cause that it is Your Ladyship, it is the court that will determine whether a witness should be called or not to testify here in court. So Your Ladyship will make that decision whether it's necessary for them to come and testify or not. So that is the position. Our attitude is we do not know how they will assist the court in determining any findings here in this court. With regard to the investigating officers that had been involved in the investigation, say after the TRC proceedings, and your Ladyship will see it's Masegela, Makua, and the present investigating officer, Colonel Dweba. They are, we could contact them. Well, Dweba is available, he is here. But his statements are before court. Makua's affidavit is before court. Masegela has made a short affidavit. But in fact, if necessary, he has indicated to us, I have consulted virtually with him. We have consulted, in fact, virtually with him some time ago. And he has indicated his availability to come and testify to court.
Don't you think it would be necessary for especially those latter investigating officers following the TRC process
Yes.
to come and testify as to?
I
should think so.
The court pleases in that regard. So that is my submissions just with regard to the investigating officers.
So when can they be available to testify?
Lady, can I be given time just to, after, say, during lunchtime, etc., just determine that issue or after the court adjourns for the day?
All right, thank you.
And then just to come back to the issue of Mr. de Kock. Our difficulties, number one, the first point we wish to make is that we are in support of Mr. Varney's application. The difficulty we have, and we have expressed it earlier this morning to all the council, is that there is a real certainty with regard to whether
Is future availability?
Yes, Mr. de Kock will be able to testify or not. And that's really the crux of the issue. And Your Ladyship will see in that report, the back, the second page, under recommendation, there is the doctor's advice is that he should rest, etc. And then the next sentence reads, he needs to be re-evaluated within the next 2 to 4 weeks. Well, we don't know whether if he is re-evaluated. Well, the date of this report, I think is it not, the last consultation was, I think the 10th of October. Yes, 10th of October. So within 2 weeks would mean 24th of October. 17 plus 24th of October would mean next week. So if he could be re-evaluated by next week, the doctor should quite possibly say that he is fit to testify in court. That's the first issue.
But you say this is uncertain.
It's uncertain. And then the issue regarding 6 months, it's just a question of whether it be fit to perhaps run a marathon or around a rugby field. So it is the uncertainty with regard to him. And we don't know whether the doctor will say within the next 2 to 4 weeks whether he is fit or not. We were thinking of a possible solution to that. And we were hoping and we thought that we might approach this court for an order that he be evaluated by an independent doctor. Not that we don't trust this doctor. It is just that perhaps it would be better for an independent evaluation by a suitable specialist or medical practitioner to give this court an opinion as to his fitness to testify, whether in person or virtually. Because surely if he can testify virtually.
How soon is it envisaged that that could happen if the court were to go that route?
Malady again, we could. Sorry, Malady. Maybe Friday, Malady. I'm sure we could do that as quickly as possible.
But that doesn't really cater for the problem at hand. The fact that from now on, what then the witnesses that are lined up to testify.
Yes, I think the only eventuality or what would perhaps happen is that some of the witnesses will have to be moved to next week. And that was, in fact, we were hoping that perhaps Mr. de Kock could testify next week. In fact, the other issue I just wanted to mention is that Mr. de Kock's evidence, as far as we are concerned, is very important. Because he also makes mention in his evidence to the TRC. At the hearings at the TRC, he makes mention of, although it could be regarded as hearsay evidence, he still makes mention of the fact that former general or retired General Engelbrecht had been involved in the disappearance of the tickets that had been issued to this car, this vehicle. It had been used by the security forces at the time of the killing of the Cradock 4. And apart from that, it is also clear that from the TRC evidence, his TRC evidence, that he had been aware of the death or the identity of the killers shortly after the killing of the Cradock 4. And that is in July 1985. He had been told by Van Zyl that they had been involved in the killing. And he was at Vlakplaats.
I don't think there's a dispute about
yes,
as regards his
the importance of his
testifying.
Yes,
or shedding some light about what he knows to this court.
As a court, please.
Yes, Mr. Celia.
I'll be brief as well. Lady, what we are concerned with here are actually the basic principles of fairness. My lady, and although we're not involved in a criminal trial, governed by the Criminal Procedure Act, the constitutional principles of fairness clearly will apply to proceedings of this nature as well. And my lady, apart from the fact that the Constitution will govern also proceedings of this nature. We also, of course, have Section 8 in brackets 2 of the Inquest Act that specifically provides that the laws governing criminal trials shall mutatis mutandis apply to these proceedings, including to the examination of witnesses. So all the rights provided for an accused person should be applied as far as it can be done, mutatis mutandis. My lady and I would respectfully submit that will include the right where you are specifically and formally listed by the state and or by all the parties accepted before you that these persons I represent are what is referred to as persons of interest stroke suspects. They stand to be confronted in the end with a finding that will be very prejudicial to their positions. And therefore, they are, I would respectfully submit, entitled to all relevant principles of fairness that will govern also a criminal trial. My lady, the facts, of course, are apart from the fact that they are listed as persons of interest. It is clear, our learned colleague on behalf of the state mentioned that to some extent, that there will be apparently an attempt or attempted implication by Mr. Cock on at least some of these witnesses that we represent. My lady, and then the next question that will arise, sorry, of course, another issue also just touched on by our learned colleague on behalf of the state. We don't have a statement of Mr. de Kock relating to the present proceedings. We don't know on what basis he may or will implicate our clients. What we do know is that there is the real stated possibility or probability that he will do so. And my lady, all I can respectfully submit is that if you properly apply the principles of fairness, then the first principle of fairness, or the first issue or aspect that should follow a fair process vis-à-vis the interested parties would be that if they are confronted in the witness box with cross-examination, not only by the state but also by our learned colleagues on behalf of the communities and family members, that they at least know what they have to face. It will be, I would respectfully submit, grossly unfair to have them in the witness box under circumstances where they are not certain with what facts and or allegations, or alleged facts and or allegations, they will be confronted with. My lady, that led to various instances where you applied these principles. And I'm not saying you're bound by that, but you did give very clear directions previously on a number of occasions where I was at least present, that all these persons must testify, persons that potentially implicate the interested parties must testify before they should come to the, or forced to the witness box. My lady, that was a proper application of the principles of fairness. And again, I'm not suggesting that your ladyship, that was cast in stone and that your ladyship can not under very special circumstances change that procedural arrangement and or directives that you provided. But my lady, there should be very, very specific reasons that should be required for you to move from that prima facie fair directives that you've issued. And I understand, my lady, that we are confronted with this uncertain position of Mr. de Kock. And yes, obviously you want to have this inquest finalized. It's 40 plus years after the incident already. Not that any of the interested parties are to be blamed for that. That blame, well, let me not go to the blame thereof, but we all know it's not the interested parties who are to blame for that. My lady, what Mr. Goldman suggested, for instance, is that Mr. de Kock should be maybe referred to an outside doctor. That doctor, if I understood him correct, may find that Mr. de Kock is indeed able to testify, not only in 2 to 4 weeks, maybe already by next week, maybe virtually. And so the question is whether it's in the interest of justice that you reverse your previous directives, that you come to a conclusion that fairness doesn't now require any further, that the witnesses implicating the interested party should testify first, under circumstances where Mr. de Kock may be before you during the course of next week or shortly thereafter. So at this stage, I would respectfully submit that it's premature for that decision to be taken at this stage, even if you have the jurisdiction and power to revisit your previous directives. It should not be done in haste. You should first have all the facts before you. And the uncertainty of Mr. de Kock's situation, I would respectfully submit, should first be cleared up before you take that drastic decision. Because it will indeed have a very drastic effect, my lady. Then, as far as the interest of justice is concerned, yes, I'm sure that on the one hand, one can say that the interest of justice will require a speedily finalization of these proceedings and process. Yes, we agree with that. But my lady, on the other hand side, we have also the interest of justice that would require fair notice to a witness to come and testify, the fair opportunity to have proper consultations and preparation after having knowledge of all allegations that he or she will have to face. Because one can never allow, my lady, cross-examination of a witness on the ambush basis that he may or will be, or she may or will be confronted with facts and or allegations that he or she may not be aware of, and had the opportunity to prepare on that, had the opportunity to consult on that. That should be avoided, my lady, even if one can say that a court will have the jurisdiction to do so. It will only, I would respectfully submit, be done in very special circumstances. My lady, then the next question that arises, and I don't think, or I'll ask a direction from you whether it's necessary for you to deal with that now. That's the practical situation then. If you make the order this afternoon now that the interested parties can and should testify even before Mr. de Kock and or the investigating officers testified, then the question is when. The problem that, the practical present problem that we have is that Mr. de Kock was scheduled for testifying tomorrow. My lady, and speaking on behalf of my clients, it's impossible to have anybody to substitute for Mr. de Kock tomorrow or the day after. What we've seen from Mr. Vardy's rescheduling of events was that he now just decided that he changed the schedule. Mr. Williamson, who was arranged to testify next week on Tuesday, is now moved back to take the place of Mr. de Kock. My lady, the clients that me and my attorney represent are elderly gentlemen. General Erasmus, as you know, is 89 years of age. I think General Engelbrecht is in his mid-80s. And Mr. Williamson is between his mid-70s and 80. They are elderly gentlemen, and if you make the ruling, I don't want to waste your time now to schedule them, but then to ask for maybe a meeting in your chambers and or a meeting between the colleagues in order then to prepare a schedule to have them here. You are aware of the fact already that General Engelbrecht has already provided medical certificate that he is willing to testify, but he can't travel at this stage. But he is willing to testify. I think he was then scheduled for next week on Wednesday via a virtual link. That can stand. As far as Mr. Williamson is concerned, if you make the order that he must testify before Mr. de Kock, we would request that he remains on his place Tuesday next week. As far as General Erasmus is concerned, my lady, he had a very serious medical setback. He can't travel at all now, but he's also willing to testify virtually if you make the order. I would submit that we then arrange him to maybe fall in with the General Engelbrecht link on next week on Wednesday. But I don't want to waste too much time with that issue. I persist with the argument that at this stage it is premature before we really know now what is Mr. de Kock's position and what the position is of the investigating officers to make the ruling now. If subsequently you decide to do so, we can make the arrangements. Those are my submissions, my lady.
Okay. I'm usually very loath to second guess a doctor, so I'm not sure I'm comfortable with the suggestion that Mr. de Kock be subjected to another examination. But that's just my view.
I agree with you, especially under circumstances where there are no factual basis for the second guessing, my lady.
Your concerns regarding fairness to your client or the client's consent will they not be addressed by the suggestion that they be given a right to reply, which will include cross-examination at a later stage?
My lady, are you referring to the fact that they can reply by cross-examining Mr. de Kock subsequently? Well, obviously, and of course, that will follow. But my lady, the problem is if they get into the witness box and they have to be cross-examined, they will be cross-examined, for instance, on issues that we are not aware of and that they are totally caught by, with respect, and I'm not saying it in a bad way, by ambush, that they will then be confronted with events. For instance, take General Erasmus, 89 years old, an event that occurred some 40 plus years ago, and he will be forced to be cross-examined and be confronted with allegations and suggestions that he wasn't made aware of before he entered the witness box and didn't have the opportunity to go through his documentation, to consult with his legal representatives, my lady. And although it may provide some comfort, the fact that Mr. de Kock can be cross-examined, it doesn't take away the the prejudice that the witnesses will have when they have to face cross-examination under circumstances that they are not prepared for all allegations against them.
Is this because, Mr. de Kock, you are not in possession of Mr. de Kock's statement?
No, we are not sure what he will say. What we have is thousands and thousands of pages of truth and reconciliation records, etc., but we don't know exactly what Mr. de Kock will be deemed necessary or relevant to raise during his evidence.
You have indicated that the court must consider all the facts. You haven't addressed yourself to the facts that, as you also appreciate, you have just appreciated that the witnesses are elderly.
Yes.
So the issue that has been brought forward is necessitating that they testify sooner than later. Is that fact exactly, that they are aged and that the more time passes, the more difficult it may be to have them testify, maybe due to ill health or passing away and taking the whatever knowledge they have to the grave?
My lady, certainly I suppose that is one of the considerations that you will look at. On the other hand, my lady, it will be a sad day if an elderly person's right to fair proceedings are taken away from him because he's old.
Will that be amount to
Well,
discrimination?
That will be the practical effect thereof.
Yes, any other submissions? You wish to make?
That concludes my argument, my lady.
Thank you. What is the position with Mr. de Kock's statement?
Thank you, my lady. Your ladyship would have noted that we were requested to provide a statement. We said we will provide a statement after we've been furnished with the statements of Mr. Olamisa and Mr. Goniwe. We only received Mr. Olamisa's statement on Friday, and that is also the date that we were advised that Mr. de Kock is suffering from heart failure. However, if this will assist the court, my lady, from our side, Mr. de Kock will only testify about exactly what he said at the TRC. We agreed with Mr. Coltman that we will lead Mr. de Kock, and during our previous consultation that Mr. de Kock indicated that what he testified at the TRC is what he can remember. So we will only lead him on that. I don't think that helps my learned colleagues because Mr. Coltman and Mr. Varney can ask various other questions which could implicate them. But from our side, we are going to stick with his evidence as per the TRC. We don't know what will happen in cross-examination, and if it will assist the court, we already prepared Mr. de Kock's statement up until Mr. Olamisa's statement. We will probably be able to provide his statement tomorrow. I don't know if we will be able to provide a commissioned copy by tomorrow, but we will be at least able to provide an uncommissioned copy by tomorrow. But that copy will be in line with his TRC statement, my lady.
Thank you.
As it pleases.
Okay, before I give Mr. Vani an opportunity to, sorry, Mr. Sakela, before I give Mr. Vani an opportunity to reply, is there anyone else, any other party who wishes to make their submissions?
Lady, if I may make certain submissions, I agree with those made by Mr. Sillier. My client is also in the exact same position, my lady. During the TRC proceedings, there were certain allegations made by Mr. de Kock with regards to earlier the signal and certain structures in the South African Defence Force. And as we've seen now during the evidence of Mr. Olamisa as well as Mr. Goniwe is still in the witness box, although we were provided with statements, obviously the evidence eventually in court are not limited to the statements. There are more new documents. There are 12,000 pages of documents that we in the short period that we had at our disposal since our appointment on the 15th of September did not have the opportunity to peruse all of that. Mr. Varney referred during the cross-examination of Mr. Olamisa today to certain documentation that I only saw today for the first time, although I've seen a similar document of that specific operation. There's also that difficulty that we have, that we do not have all the time that the other parties had to prepare for these proceedings, and we are participating, and it's obviously for us very important in order to properly consult with our client to be aware of what are the allegations are and the evidence is that has been tendered against him, and we submit that he will be prejudiced if we are not in that position. And for the same reason, then we submit that the evidence of Mr. de Kock should be heard before that of our client or any of the other implicated persons. He is also an elderly person. He's 83 years old, my lady, and even more so, I submit it's important that he is properly aware of what are the allegations against him. 30 years ago, he testified in the same proceedings and is now confronted with that same position again. We know there are new evidence in respect of the TRC applications that were brought and the policemen that brought the amnesty applications, and he might also be confronted with that. So we submit that it's important that the evidence of Mr. de Kock be led first, and after that the implicated persons as a court basis.
My lady, may I just add that I also align myself with the argument of Mr. Smith. My client is also 85 years old. I've disclosed his medical certificate to Mr. Klopman and my learned friend here. I've contact my office. They've got a copy there that he makes an affidavit regarding that medical certificate. As soon as I get it, I'll present it to the court. Thank you.
Thank you. Yes, Mr. Sakela.
Yes, my lady. My lady, we support the application for the other persons of interest to testify before Mr. de Kock, because, my lady, we have traveled a long road trying to have this inquest for many years. It's been too long for the communities waiting for justice. My learned friend seems to be putting the right or the fairness, the principles of fairness above the interest of justice for the victims, for the families, for the community, for the South Africans. South Africans, not only the communities and the affected community of Cradock 4, and the families. South Africans are waiting for the truth. The whole world is waiting for the truth as to who is responsible for the killings of the Cradock 4. Now my learned friends keeps on postponing, wanting this thing to be delayed further. We want these people to come even before Mr. de Kock. I've never heard, my lady, a situation where it is required for persons of interest to be given answers before cross-examination. Effectively, what they want to be assured.
Sorry, I don't follow.
So what they want to be assured that Mr. de Kock will not implicate their witnesses, their clients, before the hearing. That's why the certainty that they want to hear. But they cannot get that certainty because the legal representative who's representing Mr. de Kock is telling us now that according to his knowledge, there will be no implication. He will lead Mr. de Kock based on what was in the TRC. What transpired during cross-examination is out of his hand, is out of Mr. de Kock's hand, is out of anyone's hand. That answer will be elicited through the cross-examination. So how can you be preemptive to say you do not want an answer that will implicate? They talk about a possibility of implicating. There is no assurance. No one has said Mr. de Kock is going to implicate their clients. Why they worry so much? They shouldn't worry. We must proceed. We have to proceed.
Don't I hear a suggestion? I haven't gone through the TRC proceedings, that during the TRC proceedings, he did implicate some of the persons of interest, be they still alive or
those that I remember that they were implicated heavily are those that are no longer alive. And I'm not sure about those that are alive, my lady. But even if that is the issue, My lady, the principles of fairness cannot override the interest of justice for the communities. Now, what they are pushing forward is that the suspects must enjoy more rights than the communities, than the families who are the victims. My lady, any frustration that is taking place in this inquest is adding a huge trauma to the community, to the members of the families that have been affected. Is adding a huge trauma to them because they see justice being postponed for them on a daily basis. So we must not allow that to happen. We must stop it, my lady. That's our submission. My lady, I'm not sure whether there is anything. So that's what I wanted to address, my lady, because there is no real possibility. My learned friend is saying there is a real possibility, but he cannot point to us any fact or any situation where Mr. Tikoko can implicate his witness. It's not there. He would remain speculating that he might. There is a possibility. My lady, we suggest that we must proceed as planned, and if Mr. Tikoko is not available, we are told that Mr. Tikoko will be available by the month, within the month. Seemingly, Mr. Tikoko is committed to avail himself. If he does so, even during the hearing, if Mr. Tikoko is available, we can take his evidence via virtual hearing. But we need to proceed. Thank you, my lady. That's our submission.
Thank you, Mr. Sakela.
Lady, may I just add, as far as I know, fairness is justice. You can't split the two.
Thank you. Yes, Mr. Vani.
As my lady pleases. My lady, first let me address the issue of persons of interest being ambushed while they're on the stand. My lady, we don't intend to engage in the practice of ambushing. That simply isn't the case. In fact, my lady, we have already provided the extracts, the documents we intend to rely on per witness. We've passed these on to all the teams. They have them. They know what documents we're going to be relying on. It is correct that we will also be relying on the TRC report and the amnesty process, and I agree with my learned friend Mr. Van Zyl. Yes, that's a huge report and the thousands of ancillary documents. But again, my lady, we have taken the step of providing Mr. Saliers and his team with the actual paragraphs we intend to use. We've sent them already in relation to the three witnesses that Mr. Saliers is representing. So it's quite apparent, my lady, that there's no danger of an ambush, and we will do the same courtesy in respect of the other persons of interest. Finally, my lady, on the question of balancing these competing rights of fairness and ensuring that there is an expeditious hearing after all these years, my learned friend Mr. Saliers pointed out correctly that where special circumstances exist, my lady must be very concerned about ensuring that those special circumstances factor into her decision. And what are these special circumstances? My learned friends have pointed it out. As your ladyship reminded them, all these persons of interest are elderly. Several of them are in their mid to late 80s. Several are already too infirm and ill to travel. I pointed out that several witnesses who we would wanted to have testified have passed on already. We will never hear from them again. We have lost the opportunity of preserving their evidence for the record. And so, my lady, we would suggest that when it comes to balancing these different considerations, the balance of convenience has to weigh heavily in favor of putting their evidence on record and not permanently losing that evidence. If indeed the individuals in question were in their 20s and 30s or 40s, yes, then time is on our side. My lady, time is no longer on our side. we certainly do not want to put ourselves in the embarrassing situation where we have to explain to the public at large why it is that certain individuals never got to testify when there was an opportunity to hear from them. And finally, my lady, it's not as if there aren't measures that can be taken to protect and ensure that the rights of the persons of interest are protected. In the first place, we will provide, and we have done so, the evidence in which we intend to put to the individuals in question. They will have time to prepare themselves. And secondly, if Mr. de Kock comes along and provides additional information or implicates other individuals, then we would submit that they be given the right to cross-examine Mr. de Kock and reappear themselves if needs be, and if convenience determines virtually as well. So in short, my lady, we believe there is no real obstacle in the way of this court hearing from these persons of interest, and we would urge the court to hear from them before it is too late. Those are submissions, my lady.
Thank you.
Lady, may I just mention one thing that Mr. Barney touched upon, and that's the documentation that was provided. You would recall that at the last case management meeting we requested that the other parties, both Mr. Barney's team and Mr. Nkatobi's team, identify the documentation that they intend to use. We have been provided with documentation by Mr. Varney's team, but not a single documentation by Mr. Nkatobi's team. So we also have not received that documentation in order for us to prepare our witness and to consult with him. We have not received a single document. We received the statement of Mr. Olamiza 4 days late. Only received it on Thursday evening, whilst it had to be provided by last week Monday. So we also that in this position that we cannot prepare with regards to that as well at this point in time. And my lady, let's stop beating around the bush. It's 25 years since the TRC closed its proceedings. And only last year these proceedings were reopened and that application was brought a year or what before that. And now the people that are implicated must now bear the brunt because someone else didn't do something for 25 years and now they must be forced into the witness box to give evidence without being aware of what the allegations against them are. So court, please.
Thank you. Okay, it's 10 to 1. Can we adjourn for lunch and then I will give a ruling in this matter after lunch. Can we adjourn until 2:15? Go to lecture. Okay, during the lunch break, I had an opportunity to consider the submissions that were made by the parties regarding the application that will, the nature of which will become clear during my ruling. It became apparent that Mr. Eugene de Kock, who is scheduled to testify during these proceedings, is unlikely to do so during the course of the current sitting due to ill health. This prompted an application by the representatives of the deceased families and the community that I direct that the so-called persons of interest testify as planned during this sitting before Mr. de Kock testifies. The persons of interest, which include Mr. de Kock, were during the relevant period, that is the killing of the deceased persons, attached to South African Police Service or SAP, not service, South African Defence Force, or the security cluster. The basis for the application, as I understand, is inter alia that it has taken decades since the death of the deceased for us to reach this stage. The families of the deceased persons and members of the community are keen to know the circumstances that led to the deaths of their loved ones. And that possibly the persons who are and also know the persons who are responsible for same, that therefore they have been in search of the truth for all these years. Secondly, that plans are in place for evidence in this regard to be heard during the course of the 2 weeks starting from yesterday. Thirdly, Mr. de Kock's future availability is uncertain. Another factor that was raised was that the persons of interest who are scheduled to testify during this period are of advanced age and infirm or sickly. That therefore the more delay in hearing from them, the more the risk of them not being able to provide information about what they know in this regard. The application is opposed by the representatives of the persons of interest on the basis essentially that they will suffer prejudice if they were to testify ahead of Mr. de Kock. They will testify without knowing in what way he's going to implicate them or say about them. That they are entitled to a fair notice as to what they will be required to answer to. Mr. de Kock's statement regarding his testimony, so it was further argued in these proceedings, has not been made available to the parties. I must add at this juncture that this is through no fault of Mr. de Kock or those representing him. All the parties are aware of the facts surrounding the non-availability of the statements. I have previously expressed the view that it is desirable and indeed in keeping with the notion of fairness that a person of interest should be aware of the evidence by other witnesses that implicates him or her when that person gets to testify. I do, however, appreciate that the interest of justice do not denote fairness to one party only, but suggests that fairness should take into account the needs or the interests of all the parties concerned. in the circumstances of that particular matter. Section 8.2 of the Inquest Act provides that the laws governing the criminal trials shall apply to the securing of attendance of witnesses at an inquest, the examination of witnesses, the recording of their evidence, also refers to providing them with the fees to attend court. An inquest is a fact-finding investigation, as far as I am aware, to determine inter alia the cause of death of the deceased, and all those providing information or evidence during the inquest are witnesses. In the Inquest Act, there is no distinction between witnesses and persons of interest. I must add, however, at this juncture that I am quite mindful of the risk that attaches to witnesses referred to as persons of interest, albeit not a finding of guilt, but there may be risks attached going forward to those persons. An inquest is not a criminal trial, it is inquisitorial. It is unlike in a criminal case where there are specific rights that apply to accused persons or detained persons or suspects. But once again, I must add that I am quite mindful of the risk attaching to those persons referred to as persons of interest. And the so-called, if the so-called persons of interest were to testify before Mr. de Kock, it will only be in keeping with the tenets of justice or fairness that they be provided with an opportunity to deal with the evidence Mr. de Kock might have given incriminating them, should they be so advised. This, in my view, will mitigate any prejudice they may have suffered by testifying ahead of Mr. de Kock. Unfortunately, and we have an undertaking that Mr. de Kock's statement will be made available as soon as it is possible. It may not be a commissioned one, but I'm sure the parties will be pointed to the direction in which Mr. de Kock will testify if he so testifies. In these circumstances, therefore, it is my considered view that it will be in the interest of justice that this court continues to hear the evidence of witnesses other than Mr. de Kock, or in the absence or unavailability of Mr. de Kock. It is so ordered. Yes, what next? I'm sure there would be a need to determine when and how, because I don't think it will be. We still have Mr. Koniwe's evidence. Maybe you need to put your heads together to see how soon, in fairness to the witness, they can be called upon to testify. Right. Shall we carry on now, or yes, Mr.
I
Secretary.
suppose the length of the evidence of Mr. Giniwe will be an important factor now to on the way forward.
I
So
agree.
maybe we should proceed to
I agree.
hear and finalize that evidence and then determine the further process.
I agree with you. All right. Ms. Buthelezi.
Thank you, my lady. We're going to be brief, about 20 minutes or so. My lady, may I please call Mr. Koniwe?
Yes, you can please come through to the witness stand.
My lady, as I mentioned yesterday, we had asked for an adjournment so as to compile a schedule to annexures, or rather compile a schedule of documents to which paragraphs in the last section refer to. We have subsequently done so, and we have circulated an electronic version to all the parties. I hope they've received them. We did so earlier today. And I also beg leave to hand up a physical copy for my lady. And I've also provided one to Mr. Goniwe. And I would ask that it be reference J1A. So to come subsequent to J1, which is Mr. Goniwe's affidavit. And annexures there too.
Okay, we've already taken the liberty to do so.
I'm sorry.
It is marked as such, it's okay.
Thank you, my lady. Thanks. So,
Let's hope it doesn't get lost because you did not take the liberty to have it punched so that I can file it in the relevant section.
my lady, perhaps when we are done with Mr. Goniwe's evidence, we would like to have it punched for you and return it. We have a punch here. So, my lady, I think I should first just read in. Is it necessary to read in these annexures into the record? Or let me just do so.
Okay. Mr. Koniwe, you are reminded that you are still under oath. Thank you.
So at paragraphs 72, there is an additional affidavit to which that paragraph relates to, which is that of J.H.W.F. Wilkins. This can be found in volume B2 at pages 4132 to 4134. Then at paragraphs 214, the document or affidavit to which is referenced there is that of Lawrence Duplessis, which is found at volume C, pages 410 to 415. Then at annexures 215, at paragraph 215, the document that's being referenced are minutes dated 18 June 1985. Those can be found at volume B2, pages 5084 to 5088. The next one is paragraph 216, which references a copy of a letter of the Secretariat of the SCC dated June 1985. You'll find this at volume B2 at pages 4984 to 4992. And then at paragraph 219, there would be two documents that are referenced there, one being a copy of the minute dated 18 July 1985, and the other a copy of the decision of the Amnesty Committee, AC/99/0350, found at volume D at pages 1169. At pages 1169 to 1179. Okay. Now, Mr. Goniwe, we had left off at, I believe, paragraph 210. That's your next section. And I don't intend to take you to each and every single paragraph. So, at paragraph 210, you say that as confirmed by state records, Mr. Goniwe was under round-the-clock surveillance. If that's the case, then it defies logic and experience that the assassinations of the Cradock Four occurred without the knowledge, coordination, or complicity of those conducting that surveillance. Why do you say that? Or can you elaborate on that?
I say so, my lady, because I believe firmly that
Let's try dealing with that background noise, please.
The very purpose and essence of the surveillance was finally to eliminate enemies of the state. The reason to monitor every movement that they were making was to capacitate the state apparatus to pounce on them at an appropriate time. As I say, once you take the responsibility of surveilling someone, you are equally taking into your hands the safety of that person. Because you then will have to be held to account about anything that befalls that person. It doesn't make sense, and neither is it convincing, to then say the victim of your surveillance gets impounded, gets killed, and then all of a sudden you know nothing about it. And you expect us to believe that. It's not possible. It means that you gathered information, you provided it for a specific purpose, and in this particular instance, that purpose was to remove these people permanently from society. That's why I say so. And I also stated, my lady, that this was not ordinary kind of ad hoc surveillance. It was systematic, it was consistent, it was well-resourced, it was structured. Even on the date where the Cradock 4 left Cradock, in some of the documents from the security, you get a report of the hurried departure of Eric Vender and some members of his team, also going to Port Elizabeth. And what makes it very clear to me, even after the actual death, the surveillance continued. For one purpose only, that is to cover up the entire factual situation such that we find ourselves in this situation where there isn't incorroborable evidence that can link an individual to this thing. Hence we say that they have a collective responsibility, because this was systematic. There were meetings that were sitting. The information was flowing amongst themselves about, they placed themselves in the position of a god to actually decide who has a right to live or not to live. So I'm saying that based on that, my lady.
Thank you, Mr. Guniwe. My lady, I would like to go to paragraph 72. Paragraph 72 initially only referenced
So what paragraph?
72
In my evidence.
of the statement, of Mr. Guniwe's statement.
I must be looking at.
Oh, you're probably looking at the schedule. It's J1, the file, the Archive file J1.
Yes.
His statement, Mr. Guniwe's statement would be in front. Okay,
Yes.
are you there, my lady?
Yes.
Paragraph 72. So paragraph 72, as you read it, annexes only Dirk Hutting's affidavit. With the schedule that I handed up, we also reference the affidavit.
Can you adjourn for a short while, please?
Oh.
Okay, sorry about that. Let's try again.
Thank you, my lady.
It's counsel's fault. You should not have required me to talk as much as I did. That's what you get for doing that to me. Yes, Mr. Kuni.
My lady, we were at paragraph 71.
Yes.
I just wanted to clarify that the affidavit of Mr. Hutting should be read in tandem with the affidavit of JHWF Wilkins. The affidavit of Mr. Huttings confirms the affidavit of Mr. Wilkins, and Mr. Wilkins' affidavit speaks to, although it deals with the destruction of files, it speaks to the fact that at the time, there were two instructions, one written and one verbal. And so they should be read in tandem. On its own, it does not. It seems irrelevant. So, my lady, that takes us to paragraph 131.
Yes.
Okay, so Mr. Goniu, at paragraph 131, you say that when the news of their disappearance, are you there, Mr. Goniu?
Paragraph 131.
Yes. In that bundle, is that?
This one.
Yeah.
Page?
No, not that bundle, the file, the art.
This one.
Leave a file. the page
Page?
number is 36.
Page 36.
Yeah.
36.
And,
So, paragraph 131 will say, when the news of their disappearance, that being the Cradock 4, reached us, we were immediately fearful. We activated our networks. The worst was confirmed. Now, I have a few questions for you that I should have dealt with. So, the question is, were you aware, where were you at the time, where were you on the 27th of June 1985?
yes, earlier, my lady, I did indicate that on the 26th, we had a meeting at the community hall celebrating the 30th anniversary of the Freedom Charter. Then on the 27th, there was this UDF meeting. It was a routine meeting where at Matthew, as the rural organizer of the United Democratic Front, would then proceed to go and give an update and reports about the work of organization at the rural areas.
No, my lady. So, Mr. Goniwa, were you aware that Matthew Goniwa was going to attend PE on the 27th of June?
Yes, my lady,
1985?
I was away.
Did he tell you? Were you told by somebody else? Did you have a conversation with him? When last did you speak with him?
We were together on the 26th. And on the morning of the 27th, he came to see me at my place while I was on the way to work. That was routine. We don't sleep without having spoken. In the morning, I go and check if he's safe or not.
Thank you, Mr. Goniwe. So we can now turn to, we're closing off to the conclusion, which would be so you could read paragraph 225 in before we end off, unless there's any other concluding remarks that you may have.
Yes, I do have, just to place on record, my lady, that we had a deep desire to share a perspective about what kind of approach in relation to reparations and restoration we would have preferred. However, I heard yesterday that it's not the purpose of this inquest to arrive at that point. We must place on record our disappointment about that. Because to us, these are inseparable things. They actually go together. Today, I'm reading, I speak because I must. I speak because silence in the face of such crimes would be complicity. I speak for the memory of Matthew. I speak for his wife, his children, and his descendants. I speak for the Goniwe family. I speak for the community of Cradock. And I speak in the hope that this inquest will finally do what the state, the TRC, and the courts have thus far failed to do. That is to recognize the full extent of what was done and lay the foundation for accountability and reparation. There I end.
Thank you, Mr. Goniwe. My lady, that concludes the evidence in chief.
Thank you. Mr. Coltman, any questions from the state?
I'll be assisting you, my lady.
Yes.
Mr. Goniwe, first of all, I'd like to thank you for your testimony today. I can only imagine how difficult it was for you to relive, obviously, it was something that was very tragic to yourself as well as to your family. I just have one question regarding what you testified earlier regarding where the bodies were found. You testified that you were informed of this, where the bodies were found. You were not present or there when the bodies were actually recovered. Is that correct?
That's correct, my lady.
You also, with regards to the inspection in loco, you indicate in your affidavit that you weren't in an agreement with regards to where the bodies of Mr. Goniwe and Mr. Kalata was found in St. George's Strand. You and Ms. Chalmers believed it was more towards Blue Water Bay. Is that correct?
That's correct, my lady.
And now, what I want to know is, at any stage, were you ever informed or your family informed that the bodies of Mr. Kalata and Mr. Goniwe was actually found in Skribancha, where the burnt vehicle, where Mr. Goniwe's burnt vehicle was? Did you were ever informed of that the bodies were actually there, recovered there?
No. I was never informed about that.
Are you aware of anyone in your family being, or the Kalatas being informed that the bodies were found there?
No, I have absolutely no knowledge about it.
Were you present when Mr. Zonke testified before this court regarding that evidence?
Yes, I was present.
Was that the first time that you heard this information, that this is where the bodies were located?
Yes, it was the first time.
Thank you, Mr. Goniwe. Nothing further.
Mr. Vani, any questions?
As the court pleases, yes, just a few follow-up questions. Mr. Goniwe, in your statement, paragraph 118 on page 33, you mentioned that on 30th April 1984, you were arrested alongside Mr. Fort Kalata. You were detained under security legislation, sent to Deep Kloof prison in Johannesburg, and you also referred to the fact that Matthew Goniwe and my daughter Jacobs were also detained and held in Cape Town. I think in your evidence you might have made, or before we move on, can I just check the date, because we've had reference to a TRC document which puts the date of your detention of 30th March 1984, not 30th April. So is there a possibility that you meant to say 30th March rather than 30th April?
It could be.
Could be. Milady, just for the record, we're referring to a TRC investigative document titled Cradock 4. It's in volume H at page 757. And in terms of the dates and the timing, I want to refer you to the State Security Council meeting on the 19th of March in 1984. Do you know about the meeting that the State Security Council had on the 19th of March 1984, a few weeks before you were detained?
I just saw it in some of these many documents that I cannot specifically recall.
Perhaps just to jog your memory, and my lady, the minutes of that meeting are contained at volume G, page 9 to 15. And I just want to read you a paragraph from the minutes of that meeting. It's in Afrikaans. In Cradock is daar twee oud-onderwysers wat as agitators optree. Dit sou goed wees as hulle verwyder kon word. Loosely translated, my Afrikaans-speaking friends will correct me if I'm wrong. In Cradock, there are 2 teachers who appear as agitators. It shall be good if they can be removed. Do you recall that particular meeting on the 19th of March?
I heard about it.
You heard about it.
I didn't attend the meeting.
So what I want to know from you, with the benefit of hindsight, do you see a connection between that meeting where the then Minister of Black Education, Mr. Baron du Plessis, he called for the removal of the 2 teachers, and we now know that the 2 teachers were Matthew Ganiwa and Fort Kalata. But your detentions on the 30th of March, just a few weeks after that meeting, with the benefit of hindsight, do you see a connection between your detentions and the call for the removal at that meeting?
There are many thoughts, because the whole thing emanates from a lie and a crime, which I said yesterday, and I repeat that. It's a crime that was being perpetuated by criminals in suits and ties. So it's a lie. Because that time, we were told that there are those who genuinely would like to see the unrest ended in Cradock and the demands of the community being met, addressed. Fundamental to those was the reinstatement of Matthew and Fort.
Right. We'll come back to the potential reinstatement of Matthew a little later. But would you agree that, at least in real terms, the 2 teachers who were accused of being agitators were in fact removed a few weeks later when they were detained and held outside of Cradock?
Indeed. What I was trying to give is a related context. When I'm saying we were warned, the way that they were operating, it will emerge throughout this, that you had what was called verkramptes, you had verlegtes. The people who were running education, for example, the person like DPR, I found the honesty in him, in his desire to have them reinstated. Then there were those that believed in the solution of military kind of vindictiveness and so on. Then in between there would then obviously be a human factor, human frailty. In that whole scenario, there also will be deception, because this whole system was run by people who were dishonest. So you don't know what to believe and what not to believe. It was spoken about there were communications, and indeed it happened. So we took it that it's connected, and the victory of the verkramptes over the verlegtes in that context.
I see. So in your view, the verligters, I suppose loosely translated as the reformed or the enlightened, they were trying to seek the reinstatement of Matthew Ganiwa, and with the hope of bringing stability to Cradock and the region, whereas the verkramptes, loosely translated as the hardliners, they had a different vision and approach, which was to ultimately engage in the elimination of the so-called agitators. Do I sum up your view correctly?
You do. You sum it up accurately, almost, okay.
Yes. When there were attempts, at least on the side of Department of Education, looking at the possible reinstatement, were you involved in any of those discussions with Matthew Ganiwa?
No, we're all involved, my lady, as structures. There were petitions that were written, there were deputations that I remember Franklin's son was one of the people that were high up in the educational structures, setting up this meeting with a delegation from Cradock that went up to Cape Town at own cost for a meeting with DPR, discussing this solution to the problem. So I'm aware, we started that process immediately after the suspension of Matthew, engaged the local department in Cradock, the Department of Education, and you could see that there was a higher authority that was outside of education. That was actually the main determinant of the pace of things. Instead of reinstate of Matthew, then you had the additional suspension of Ford. So we were hands-on as an organization in that process.
And did you have occasion to attend any of the meetings with Sam de Beer or any of the other education officials?
No. Apart from the preparations in terms of the line and what our argument would be, I didn't go physically to that meeting.
Right. So in your evidence, you also made reference to the infamous signal of the 7th of June, 1985. And as you pointed out, this was where Brigadier van der Westhuizen ordered Colonel Lawrence du Plessis to send a message to the Secretariat of the State Security Council. It was addressed to Major General Frederick van Rensburg. And you'll recall the words used: the urgent permanent removal of Matthew Guniwe, yourself, and Fort Kalata. Milady, that's at volume H, item 28, page 426. Now I want to draw your attention to the difference in the wording. So the minute that I quoted to you from the year before, 19th of March 1984, where Minister Baron du Plessis calls for the removal, just the removal of the two agitators, and I'd like you to compare that language with the language used in the signal of 7 June 85, where it says the urgent permanent removal from society. So they're quite different wording. Do you have a sense of the distinction between a normal removal and a permanent removal from society?
Yes, I do. In that context, normal removal could mean being detained or being banished, could be house arrest, restrictions as to how many people you can meet with at a time, reporting to the police station, and so on. That's another arsenal of constraining in engagements and interaction between people that was being used. But once you introduce the urgent and the permanent, then that means it's a decree to murder the people. Because remember, there was a huge pressure on the security system because the manner of the effective organization and mobilization that the UDF was able to master, there was an unrest all over. Actually, we were saying that the country is ripe for revolution. So that was that panic mode that actually led to even systems being collapsed, creating a state security management system where every asset of government, education, health, everything, was actually commanded from one single center which was the security management system. So that, once it says urgent, permanent, then it means kill them. The only place you cannot move from is your grave.
Yes.
That's permanent removal.
So would you agree that in its most simplest form, if it's just removal, as in a detention, well then at the end of the detention, you come back. Whereas a permanent removal, whatever that might be, there's no coming back.
Yes.
Are you in agreement?
That's correct, my lady.
Lady, I would just like at this point in time just raise an issue. We've listened now to various witnesses and what the interpretation of the signal is. A finding has been made by Judge Zitzman with regards to the meaning of the signal. And that finding is, with all due respect, binding on your ladyship, unless you decide there's a lesser or not such an intentional or intention to kill the people. But his finding was that, prima facie, in my opinion, that the signal sent by Colonel du Plessis on the instructions of Brigadier van der Westhuizen to Major General van Rensburg was a recommendation that Matthew Guniwe, Bulele Guniwe at Fort Kolata should be killed. And that this was the meaning Colonel du Plessis and Brigadier van der Westhuizen intended the signal to have. With all due respect, what any other witness will come and say what his interpretation or to repeat that interpretation doesn't take the matter any further. And with all due respect to my learned colleague, we're wasting a lot of time, people being asking over and over again, what's the difference of the meaning of permanent or not permanent or the meaning of the signal? It's been found. It's on the papers and Judge Zitzman made that finding. With all due respect, we're wasting time if we continue to listen to the interpretation of witnesses who were not privy to the situation when the signal was sent, who are not the authors of the signal. And with all due respect, we should not carry on in this way as a court, please.
Milady, I intended to move on in any event, although I'm very pleased to hear the concession from my learned friend who represents the...
It's not a concession, it was a finding that was made. That's part of the papers.
Yes, Mr. Vernon.
Well, I'm grateful for the reminder of the finding that permanent removal, in fact, meant a murder. Mr. Guniwe, let's talk about the day in question. That's the 27th of June, or before we turn to that fateful day. As part of your responsibilities, did you also have to meet with UDF structures in Port Elizabeth, people like Professor Derek Swart and others?
No, there was no formal obligation on my side.
Okay. But did you also attend those UDF meetings from time to time?
Yes, particularly when they were during weekends, because I was employed, so I was working in the week. Only if something is on a Sunday or Saturday, then I would go together.
Okay. At that time, what work were you doing?
I was working as an internal auditor in one hotel called Cradock Inn Hotel.
And you've mentioned in your evidence in chief that the day before you had been part of that community meeting in the community hall where Fort Kolata, Matthew Guniwe and others addressed the community.
Yes.
I think there was a commemorating was it the Freedom Charter? Or?
Freedom Charter, yes.
And then the next year, on the 27th of June, in your evidence in chief, you said you were not scheduled to go to PE, but you did meet with Matthew the morning before, at least on the morning of the 27th, just before he left for PE.
Yes, he came to my house. If you will recall, I said there was a forum house where we moved into, and later a bigger house was built. They were staying in that house. It's not far away. It's not far apart. So that morning, around about 7:15 there around. So he just walked in, and I was on my way out going to work. Then we had a very brief chat. Then I walked on foot. They were going to leave to PE for the UDF meeting.
Okay. Of course, you were not to know that that would be the last time you would talk to Matthew Kaniwa.
Come again?
You didn't know at that time that this would be the last interaction you would ever have with Matthew Kaniwa.
No, I wouldn't know, but
Yeah.
The way, the behavioral pattern after that then signaled something. Because as we parted at the corner of the street, I went down the street. When I was going to take the corner into Zambola Street, I looked back. He was still standing at that corner. Then we waved to each other. Then I left. So we have no clue. But as you said, we did expect anything during that time. And we had our own precautions. That they left PE at 9 o'clock still boggles my mind. So we were not pre-warned that actually on that day there would be something, though we had always expected that there could be something.
Just as a matter of interest, do you recall the exchange you had with Matthew Kaniwa that morning?
No, what he said that Mbu were going to PE, and yesterday's meeting was quite good, because the way we arranged it, I was in charge of organizing the speakers who spoke on which clause and that. So he came to say that everything went well and the meeting was well attended. Then we are going to PE, as you know. Then that's where we parted, yes.
So looking back on those days, now with the benefit of hindsight, you know that you were on the hit list, so to speak, in that signal. And your lead counsel, pointed out that, you survived the assassination by the mercy of God. Looking back on those days, where does that leave you? Knowing that if you had been in that car, you wouldn't be testifying today.
Yes, it's true that I believe that I was saved by the grace and the mercy of the Lord, as well as the protection of my ancestors. Should we have died together at the same day, this devastation that I've countenanced in the impact on my own family, I think could have been redoubled. So it leaves me with more commitment to do whatever I can at whatever cost to realize the kind of society they sacrificed their lives for. Thank you.
Thank you, Mr. Kaniwa. You said paragraph 192 of your statement, that's page 53, that you spent nearly 4 decades witnessing how justice has been delayed, diluted, and in many ways denied both to the families of Cradock 4 and the broader Cradock community. How do you explain how it is that more than 4 decades later, we're still trying to find the truth behind the Cradock 4 killings, and not a single person has been prosecuted? The question is whether the witness is in a position to explain why there's been such a delay in the investigation of this matter and why nobody has been held to account.
Do you know the reason, Mr. Koniwe?
No, I wouldn't know, ma'am. I wouldn't know.
Yes.
If I can just perhaps ask you, you were in Parliament for some years, including being head of the caucus as chief whip. So, if I can recall correctly, that was roughly between 2004 and 1994 and about 2006.
2004 to 2006.
Okay. During that time, as a member of Parliament, did you come across any information that suggested that cases like the Cradock 4 were not being investigated or perhaps being blocked? Did you come across any such information in parliamentary hearings or committees?
No, save for the cry of the victims' families, because that was not really my line function. So there's a portfolio committee on justice. So if there were such reminders, I remember many occasions, even the Cradock 4 widows communicating with Parliament about what is their hold-up to their prosecutions. I'm unable to explain it myself. I had informal discussions with the ministers of justice in passing. You wouldn't get a tangible response as to why the delay. Because I would have expected that there would be a very firm political will, there would be a passion to pursue all of these matters.
Yes.
So it just was not there. I don't know the reason.
That informal discussion with the Minister of Justice, do you recall which minister it was?
I think it was Penel Matuna.
Okay. So this was roughly around 2004, around that time?
In that, because when that parliament started, there was a lot of work. Repealing of the apartheid legislation, the drawing up of the constitution, and those meetings sometimes lasted up to 2 o'clock, 2 a.m. in the morning. On the other side, I had that feeling that, hey, I can see how the schedule is tight about this thing. Yes. And everyone then had pinned their hopes on the TRC being set up and the TRC taking that work forward. And it didn't. So that's my understanding of the situation.
Do you recall what Minister Maduna said to you in relation to the hold-up and the...
Didn't the witness not say that he could not get any tangible explanation? I think he said that already.
Oh, is that so? You couldn't get an explanation out of Mr. Maduna?
No.
Okay. Are you aware, though, that there have been recent allegations made that there was political interference in the investigation and prosecution of the TRC cases, including the Cradock 4 case?
Yes, I've heard that.
Yes. And in fact, as a result of litigation, President Ramaphosa has set up a commission under Judge Kempepe to look into that question.
Yes, I've heard that, my lady.
Just one moment, milady. Lastly, if I can take you to paragraph 196 of your statement at page 54. There you're talking about the Truth and Reconciliation Commission process, and you say the lack of participation in such a consequential process left a bitter legacy. In our view, amnesty should never have been granted unconditionally. At the very least, it should have been tied to full cooperation with the prosecutions of others or to meaningful steps towards public accountability. That did not happen. And certainly, I don't think anybody can quibble with those sentiments. And then in paragraph 197, you say, instead, the TRC gave legal reprieve to men who carried out political executions without consequence and without satisfying the very standards the TRC had claimed to uphold. In relation to the Cradock 4 case, we're aware of 8 applications for amnesty, and in fact, only 2 were granted. So only Eugene de Kock and Joop van Jaarsveld. But the actual members of the hit squad on the ground who applied for amnesty, all of them were refused amnesty. These were Hermanus Baron du Plessis, Eric Taylor, N.J. Janssen van Rensburg, Harold Snyman, Gerhard Lotz, and J.M. Saki van Sale. So in fact, most of the applicants were denied amnesty by the TRC. So I just want to put it to you that I don't think it's entirely correct to say that it was the TRC that gave them a reprieve. In fact, the TRC denied them amnesty, and there was an expectation that they would be prosecuted. So if there is blame to be apportioned, isn't that blame to be apportioned on the post-apartheid state for not prosecuting these individuals?
No, let me clarify what my context is. I'm specifically focused on those that were granted amnesty, and I raise it that it should have been conditional as part of granting amnesty, that you would have the person who receives which you grant the amnesty ready to work and give all information, all possible information that would make prosecutions possible. I say so because at inquiry, we were told that there are people, they are known, but there is no specific person who's able to come and take a witness stand in a court and actually give that evidence. So it's just information, it's not evidence. That's what we're told. And yet there are people who were intimately involved who walked scot-free. So my focus is the ones that were granted. I know about the others that were not granted.
No, that is a legitimate concern that you have, Mr. Giniwe. But in actual fact, Mr. Joop van Jaarsveld and Mr. Eugene de Kock provided extensive evidence under oath before the TRC, a great deal of evidence. And the complaint of my clients, the family members, their main complaint is that that evidence was never used. It was never pursued. As far as they are concerned, both Mr. van Jaarsveld and Mr. de Kock, of course we're talking about prior to Mr. van Jaarsveld's passing, were ready and available to cooperate with detectives and prosecutors. But
I don't think you can go beyond what the witness says. He was told, the fact that no one was prepared to take the witness stand and give evidence. I'm not sure what this will achieve.
No, I'm about to close up, milady. The only point that I wish to put to the witness is that there was an opportunity to pursue this case with the assistance of Mr. van Jaarsveld and Mr. de Kock, but the post-apartheid authorities did not seize that opportunity and allowed it to slip by. And that's one of the reasons why we don't have justice in this matter. Do you agree?
I have no reason to disagree with that. You are the legal expert. But from what I heard, I was there when de Kock was testifying. To me, he didn't have the detail as to who killed who, in which way, and what was done to cover up all of those things, because after that murder, some of these people that were denied amnesty were actually rewarded by the state. They were decorated, and their ranks were uplifted. So, yes, to a greater or lesser extent, the evidence of de Kock in particular was quite revealing. But from where I'm sitting, it didn't go as far as it should have to help this case to be a prosecutable case. So it's a matter of opinion. Let me put it
Thank
that
you, Mr.
way.
Gill.
my
No
lady.
further questions.
Thank you. Mr. Celia, Mr.
No
Fonseca?
questions from my side.
Nothing, thank you, my lady.
Thank you. Questions?
None.
Lady?
Thank you, Madam. Mr. Boniwe, I'm not going to be too long. Essentially, the testimony before this court during this inquest and also the various previous TRC hearings was essentially that Mr. Johan Martin van Zyl and his team commenced planning for an operation to murder the Cradock 4, and his instructions were to make the murders appear to be a result of a vigilante attack, which was a common cover-up tactic. That van Zyl was assisted by Lieutenant Eric Alexander Taylor, Sergeant Lotz, Warrant Officer Mugaduka, Sergeant Faku, and Shep Aksakati. And then according to van Zyl, Taylor and Lotz, that they acted on the instructions of late Nicholas Jacobus Jansen van Rensburg, a second in command of the security branch, and Hermanus du Plessis, and they were the persons who authorized the murders. And then according to Jansen van Rensburg, he received instructions from his immediate superior, the late Harold Snyman, and then Snyman in turn stated that he was told by the former Minister of Law and Order that the late Louis Legrandsie told them to deal with those in leader positions who were directly responsible for the unrest in the Eastern Cape. That is in essence the testimony that we heard here and also during the TRC. Mr. Geniwe, I'll put it to you that Mr. de Kock only became commander of Vlakplaas on 1 July 1985. That's after he took over from Brigadier Jack Cronea. And before that, he was a captain. And he described himself when he was a captain as a mere lackey, which can also be described as junior management at best. And I put it to you that none of these people that I mentioned now were at that stage members of Vlakplaas. And they were also not under Mr. de Kock's command. Now, your suggestion that Mr. de Kock was involved
Maybe respond to in bits if you
as
can.
it pleases.
Did you follow the question by Mr.
Yeah,
Skuman?
yes, I heard what the lawyer is saying about the evidence that was given in the TRC and so on.
Yes.
And
there
also,
Yes. Any comment you can offer in regard to that too?
I would say that is their evidence. It's not my evidence.
Yes. Now, this is my actual question, or that I'm posing to you, is that your suggestion that Mr. de Kock was involved in the planning or the execution of the murders is based on speculation and conjecture, and it's not supported by any fact or evidence. And then I refer you to your paragraph 203 in your statement, where you say, although I have no personal knowledge or direct evidence linking it. That is correct, that you don't have any personal knowledge or direct evidence linking Mr. de Kock to any of these atrocities,
Yes.
correct?
Had it been so, I would have tabled it.
No further
That's
questions.
my
No.
Ms. Butelezi, any re-examination?
None from me.
Thank you very much, Ms. Butelezi. Mr. Goniwe, thank you very much for your sharing your insights with us about this matter. You may be excused. Thank you very much.
Thank you, my lady.
Mr. Coltman. Or should we adjourn so that you can put your heads together and see what next?
Yes, my lady, thank you, I would appreciate.
Okay, continue, adjourn.
Yeah.